emergency, may I be permitted to mention a matter? My lord, for upgradation, I get serial number 204. I mentioned the upon notice. Under section 194N, the section requires that moment withdrawal is made from banks, the bank is deducting tax at 2% at source. And my lord, I am a tea company. I have to make payment to laborers every month. And my lord, tax at the rate to the tune of lakhs of rupees are being deducted every month at source. My lord, I have challenged the constitutional validity. And my lord, therefore, I was, if some precedent.
Give it. It may not appear immediately. It will appear after some time because there are a lot of urgent matters.
I understand. If I can make a request subject to your lordship's
I
kind.
have understood, Mr. Sen. It will appear once I see. I'll go to my chambers, see how many upgradation requests are there. I shall upgrade it in batches.
I'll be extremely grateful. I'll be extremely grateful.
For upgradation, please write your urgency, give it. I shall sleep. Please don't come and mention tomorrow it is not appearing. It will appear according to the court convenience. All the matters which have been listed as urgent matters are on the same ground. So it is difficult to upgrade every matter. Please give it. I shall see. I will not upgrade it tomorrow. I have said I shall see. Please don't press. Give it. I said I shall see it. You cannot expect it to be taken up immediately. Please give it. Please give it. Please give it.
So I shall give the writing the urgency.
Yes, write the urgency.
Give it to the
Yes. Yes, madam.
My junior will come and.
So it has gone to the original position. Please wait. Yes. You should have been there. See, you mentioned for urgency. If it is upgraded, then you don't appear. Then you again mention to get it upgraded. This can't. You just now saw so many urgent matters are there. Everybody is mentioning. I have been upgrading it. Please wait for some time. You have lost your chance. Please wait. Very well. Chalo. I will not upgrade it now, madam, since it was you have already had your chance once. So it will come in the list in the usual course now, because it was there in the urgent list. You did not appear on that day. So, yes, chalo. T2.
Milord, I am for the respondent number 10.
Yes. Yes, yesterday I directed. No, it is a matter which pertains to this determination.
I have also seen, my lord, I made a, I have seen this.
That is why I have kept it.
Clearing representation, my lord. They have nothing to say about.
Whatever, the matter is not a.
I have seen entire, my lord.
So that is why I have kept it as to be mentioned. It will remain in the list. It will be taken up on Thursday. Right. Yesterday I had thought that I don't have determination. So.
Representation shows otherwise, Milord. This is
representation may show. What does the representation show?
This is.
In the case, it is different. In the writ petition, it is different.
No, there is no specific government regarding the government.
The writ petition says that it is for unauthorized.
Yes.
Find any other representation.
Very difficult.
Paragraph 4 also stated that land of Jila Parishad.
Jila Parishad means then unauthorized, it falls under Public Premises Eviction of Unauthorized Occupants Act. So this court will have determination then in that case.
My lord, made a phrase repeated because this authority and my lord filed the supplementary evidence.
Where is he? Why? He is unwell. Already I'm making it not today. On the next day if he comes. Not today. Huh? Fine. I'm directing it to appear in the same list on Thursday as unauthorized occupants matter. Because it becomes peculiar then. Prayer is there. In his absence, I cannot even pass any order. Making it not today simply. Let us see. On Monday, you come and appear. We shall see.
But instead of Monday, your lordship kindly make it Tuesday. My lord. I have some difficulties on Monday, my lord.
You are not required. If I am not satisfied that I don't have determination, I will release it. And if I am required to hear it, I will post it on Thursday. Unauthorized occupants day.
Yes.
Today I am not passing any order.
My lord, may I have my lord's leave, my lord? I appear for the petitioner. My lord, I'm led by Mr. Jishnu Chaudhary. I'm told he's on the way. Lordship, because of the urgency in the matter, my lord, may I start? Lord, he'll come
Urgency in the matter. Last day you were not there.
My lord, I believe, my lord, the list collapse and my lord, the problem is that we have to, we are running to this court, lordship, when we found that it's already happened.
Because I beg to appear for the respondent.
Yes.
My lord, this concerns, my lord, this concerns the master directions issued by the Reserve Bank for declaration of an my lord, I'm led by Mr. Chaudhary. Right side.
Lord, issue is, my lord, declaration of, my lord, fraud under the RBI guidelines. My lord, this is, my lord, consortium lending. So, my lord, many of the banks, my lord, had gone through with this and we challenged because the procedure was not being followed. Now, there are several judgments, my lord. Long and short of it, my lord, what till now, my lord, has been held is this. You have to give me a show cause notice with document that you rely upon, which is the usual, my lord, thing to be done, which is the law on show cause notices. Show cause notice with documents. I give my reply. When I give my reply, I may ask for further documents. Then you give me those further documents. I, my lord, thereafter give, my lord, a further reply. Then there's a hearing and a declaration, if at all there is to be one. This, my lord, is laid down in this petitioner's matters itself, plus there are, my lord, other judgments. Now, in this case, my lord, something very peculiar has happened. My lord, there is a declaration of fraud on 5th or 7th of April 2022. It's dated 5th, it's communicated on the 7th. It's dated 4th, it's communicated on the 7th, my lord, to RBI and not communicated to us, which we find out later. After that, my lord, is a show cause notice, which is dated 26th of December 2024. 2.5 years later. So we don't know, my lord, whether there was an actual communication or not. Now, based on, my lord, declaration, there is an FIR made. I file a writ petition, my lord, once, my lord, this is challenged. Once, my lord, I come to know, since I get the show cause notice, I file the writ petition. Subsequently, my lord, they lodge an FIR from where, my lord, I come to learn of all of this. So, my lord, here I am challenging two things, my lord. Number one is the declaration which was done without adherence to the formalities. We may be, my lord, to be fair to the bank, in 2022, the circular did not mention any of this. So, my lord, they were proceeded to do it. Subsequently, my lord, the Rajesh Agarwal judgment of the Supreme Court makes it clear. But in any case, A, this declaration is, my lord, contrary to law, and B, my lord, it's been waived by the show cause notice. Now, my lord, I want, my lord, that the declaration of 2022 be set aside. Subsequently, my lord, as per law laid down by the several judgments in the petitioner's case, I may respond, my lord, if your lordship now gives me little time, I will respond and ask for documents. Because there are instances where I have, my lord, filed a writ petition without asking for the documents, and those have not been allowed. And, my lord, I have to reply. And there are, my lord, numerous instances where I have replied and asked for documents, and I have succeeded. Lord, so this is, my lord, the gamut of the matter. May I show your lordship the documents first? Please, my lord, come to page 1009. This is in volume 3. This is the show cause, which is dated 26th of December 2024. Yes. Lord, please come to, Lord, the usual credit facilities, etc. Then this is peculiar. Next page, my lord, 1010. The conduct of the account was not in compliance with the agreed terms of the loan document. The terms and conditions on which the credit facilities were sanctioned, second paragraph, had not been adhered to. Also, default in repayment, frequent breach in the terms of the facility. After due examination of the conduct of the account and utilization of credit facilities, the bank had been prima facie satisfied that there were signals of fraud in the account, which was investigated, and the account was declared as fraud on dated 7th April 22. So that if there is already a declaration of fraud, what is the purpose of, my lord, this notice? Now, my lord, please come to the end of the notice. At page 1024. You are, Lord, 1024 at the end. You are being given opportunity of hearing and requested to give written submission, if any, on any of the irregularities pointed out, leading to declaration of account as fraud within 21 days. There cannot, my lord, be a post facto show cause. Now, Lord, please see the circular once. I'll not quickly take your lordship through it. Page 94, which is in volume 1. 94 it starts. Lord, please come to 118.
একটু আলাদা করে রাখুন তো ছিঁড়ে যেতে পেজ 91
99, sorry, my lord, 94.
94
94 at, my lord, I'll come straight away to 118. Lord, in 8 clause 8.9.4 and 8.9.5 simply mentions, my lord, that if after audit, etc., detection, you have to declare as fraud.
Yes.
Now, my lord, now, my lord, this was construed in Rajesh Agarwal, State Bank of India versus Rajesh Agarwal, 2023, 6 STC, page 1. Now, please come straight away to paragraph 85, internal page 43. There are not civil and evil consequences, even criminal consequences. So, my lord, paragraph 85, fairness in action requires that procedures which permit impairment of fundamental rights ought to be just, fair, and reasonable. That's my lord, paragraph 85. Principles of natural justice have universal application and constitute an important facet of procedural propriety. Then paragraph 87, administrative proceedings which entail civil consequences must be read consistent with the principles of natural justice to meet the requirement of Article 14. Paragraph 87 itself, 87. Administrative proceedings which entail significant civil consequences must be read. Where possible, rules of audioltum partem ought to be read into. Then, my lord, last line of the page, the master directions of fraud do not expressly provide the borrowers an opportunity of being heard before classifying the borrower's account as fraud. Audioltum partem must be read into the provisions of master direction. Must be read into master direction. Then, my lord, paragraph 90. The C.B. Gautam judgment of the Income Tax Act, my lord, is not considered. Natural justice must be read into a statute. And paragraph 93. Is the conclusion that the fourth line, paragraph 93. Since master directions on fraud do not expressly provide an opportunity of being heard to the borrower before classifying an account as fraud, the rule of audioltum partem has to be read into the provisions of the said directions to save them from the vice of arbitrariness. Then, paragraph 94, willful defaulter analogy is drawn. And 95, in light of the legal position, we hold that rule of audioltum partem ought to be read into clause 8.9.4 and 5 of the master directions on fraud. Consistent with the principles of natural justice, the lender bank should provide an opportunity to a borrower by furnishing a copy of audit report and allow the borrower reasonable opportunity to submit a representation before classifying the account as fraud. Reasoned order has to be issued on the objections addressed by the borrower. On perusal, it is indubitable that the lender bank did not provide opportunity of hearing before classifying their accounts as fraud. Therefore, the impugned decision to classify the borrower account as fraud is vitiated by the failure to observe the rule of audioltum partem. Present batch of matters, ad interim order restraining the bank, the whole decision is violative. So then, my lord, the conclusions. And my lord, paragraph 99, judgment will not upheld. So, my lord, just based on this my lord, decision, which has not even been provided to me, dated 7th April 2022, my lord, may be set aside. Now, my lord, the next issue which comes is the so-called notice, though issued subsequent which is page 1009. Question is what is to be done with it. My lord, I can ask for quashing because show cause notice issued after is my lord meaningless. But they will my lord come issue the same notice by altering the last paragraph. My lord, please have a look at these. No, no. Procedure has to go. My lord, in a batch of matters, oh, that's why it is so thick. My lord, this petitioner, my lord, when the first, my lord, matter was taken up and argued, here, my lord, show cause notice had been given. There was no declaration. After, my lord, we challenged, my lord, please see, my lord, page 18, paragraph 60. This has been a series of orders.
Page 18, paragraph 60.
60, my lord.
Yes.
Hence, what has to be ensured is that specific instances of allegations are to be mentioned in the show cause notice, although all particulars and particular documents which are to be relied upon and or intricate details of fraud need not be given at the show cause notice stage. Show cause is indicator of allegation. It is to ensure an effective opportunity of hearing. Now, my lord, paragraph 64. This, my lord, is the 63. Lord, please have a look at page paragraph 63 also. Keeping such backdrop in mind in the light of judgments rendered in Rajesh Agarwal Supra and Neptune Overseas Limited Supra, following procedure is in the opinion of the court apt to serve the purposes of master direction as well as take care of the principles of natural justice, in particular the tenet of audio altrum partem, and ensure that effective opportunity of rebutting allegations is given to the borrower and JSS. First, a show cause notice is to be issued enumerating the exact offences alleged against the borrower director. If any forensic audit report or other document forms the basis of the show cause notice, the same is to be served along with the show cause notice. Then fortnight would be ample time to give reply to show cause notice. In its reply, noticing, apart from addressing allegations and controverting those specifically, specify the documents which are required to be provided to the noticee by the bank's financial institutions. If necessary, in the reply, borrower director or promoter can reserve its right to give a further additional reply upon receiving such documents. Within a week from receiving such replies, bank can give inspection. Then within a further fortnight, noticee borrower can be given opportunity to file additional reply in the light of the documents which have now been inspected. Upon such hearing, decision shall be taken whether or not to declare the borrower as fraud. So, beloved, this was the procedure laid down in this batch of writ petitions. Now, here, my lord, if your lordship comes back to paragraph 64, assuming, my lord, that your lordship, my lord, sets aside the declaration which is expressly contrary to Rajesh Agarwal, paragraph 64 itself has not been fully complied with because it says, so cause enumerating exact offences if any FAR or other document forms the basis of the show cause, same is to be served along with the show cause notice. So, up to here, my lord, only the show cause, if it's considered appropriate, if show cause is kept, my lord, in that case, the documents are required to be given. Now, my lord, in these batch of matters, there are several matters where during the pendency of the show cause, my lord, the writ petition, they proceeded without providing documents. They proceeded to declare the petitioner as fraud. All of those, my lord, were set aside. My lord, please come to paragraph 72. In this matter itself, there was a declaration. Please see, my lord, page 20. Not in the, this has a bunch of judgments not stitched together. Not page, paragraph 72, page 20.
Yes.
In view of the shortcomings on the part of the authorities in all the above cases, the consequential action of declaring the petitioner as fraud and perpetrator of fraud by Bank of India and Bank of India cannot be sustained. So this was not set aside and we were asked to not de novo proceed. Then, my lord, the petitions were disposed of, laying down the procedure which, my lord, I had shown your lordship, my lord, earlier. Now, my lord, the second order, my lord, is in respect of Central Bank of India and Punjab National Bank and South Indian Bank, 9th August 2024.
Yes.
My lord, when the matter learned counsel made over an agreed order, and my lord, please see, my lord, the consent order which has been passed. Because we used the first judgment and my lord did this. Here also, my lord, in this case, second case, my lord, which I was reading, there was no declaration, so no question of setting aside. Yes, we had not even responded. Now, my lord, third one is dated 23rd September 2024. Here, my lord, it was stayed and affidavits were directed. Lord, this is Indian Bank. Same thing. On the ground of non-supply of document. Then, my lord, 19th March 2025. Lord, we did not know that there was a declaration as fraud, so we were not given the documents, paragraph 8. We were granted leave to apply seeking documents. Paragraph 8. And on paragraph 11, order of fraud was directed to be kept in abeyance. But that was better because there was a show cause note, at least a show cause was issued before the fraud was declared. Now, my lord, please see 19th March 25. The earlier order followed. Then, my lord, 15th December 25. This is NABARD. Again, my lord, declaration quashed in paragraph 6 and direction given to supply the documents in paragraph 7. Now, recently, my lord, after all of this, matter went before another coordinate bench, my lord. Yes, several learned judges who have asked that this is the judgment. On 10th of February. there are two judgments inside here, my lord. The first, my lord, is Punjab National Bank. In Punjab National Bank, paragraph 22, entire documents not supplied. And, my lord, paragraph 23, the court finds that the petitioners have specified the documents which the petitioners are required to give proper reply to so-called notices. Respondent is directed to supply documents. If voluminous inspection, etc., and then, my lord, procedure to be followed. Then, my lord, Indian Overseas Bank, same, my lord, paragraph 17. Now, my lord, this is something I must tell your lordship, because I am aware, in respect of Karnataka Bank and DBS, my lord, our writ petitions were dismissed on the same day, my lord, as the very recent last week, 10th February. It was dismissed because there, my lord, no declaration. Because we did not reply and ask for the document, our writ petitions were dismissed. Basically giving us, we have to apply, but there's been no declaration of fraud. We have to apply for documents, and then, my lord, the same procedure was followed. Yes, but liberty granted to ask for these documents. So I thought I should tell your lordship that, so, my lord, in this position, though, my lord, truly speaking, so-called, as, my lord, in the first judgment I showed your lordship, it is the duty of the bank to give us the documents with the show cause notice. So truly, and that's been, my lord, held in several of these earlier. So truly speaking, the direction should have been there, but doesn't matter. It just asks me to ask for the documents, and then, my lord, I'll get the documents in terms of the earlier judgment. My lord, just we have cited, my lord, the Supreme Court judgment in Neptune Overseas, this in the first matter, which was followed. Your lordship remembers following Rajesh Agarwal and Neptune. This is, my lord, Neptune 2020, volume 20, is Supreme Court cases 106. But my learned friend appears for the banks in most of the matters. You have to prepare a file and give it to my learned friend. These same judgments we've been giving her for a long time. Paragraph 32. We have no doubt that a proper show cause notice was served on the respondent number 2. The moot point, however, remains as what is the effect of not serving him with the documents. This, my lord, was a SEBI matter. What is the effect of not serving him with the documents he sought for and within the compass of time which was given to him? Once again, it may be stated, large part of documents not free to inspect. Paragraph 34, we fail to appreciate why there should have been a cussedness in handing over copies of documents when serious allegations and serious consequences would flow. And there was a direction, my lord, to give documents, which was followed by Justice Bhattacharya in the first matter. In paragraph 40.2, so two classes of documents. One, my lord, documents in defense, and two, my lord, documents relied upon in the show cause notice. Not only is it required for documents relied upon in the show cause notice to be given to me, but, my lord, if there are documents in my defense which I need, those must also be given to me. because they are, my lord, with the petitioner, with the bank. Now, for example, in this case, what has happened is I was in control of, my lord, the two Shrey entities, Shrey Infrastructure and Shrey Equipment Finance. In October 2021, the Reserve Bank of India appointed an administrator, superseded the board. 3 days later, it went into IBC. And Miller, I went out of the company. Now, these two Shrey companies have been taken over by a resolution plan in the NCLT by NARCIL, which is, Miller, all the nationalized banks together forming a company. So all these banks are, Miller, shareholder banks of NARCIL. So, Miller, they have control of the documents. I am totally out of the two Shrey companies. So whatever documents I need must be given to me. So, my lord, to summarize, in my lord, this I am, my lord, persuaded to, my lord, hand up 2022 8 SCC 162. My lord, paragraph number 25 to 30. Now, this is duty to disclose investigative material. Your lordship would see why it is required, fair trial, etc. And this also, my lord, goes on to indicate whether No, we have to stop citing judgments. Neptune is considered in Justice Bhattacharya's judgment. This is also considered. There is a beautiful judgment of the Bombay High Court which we keep citing, which they were not wanting me to. So, Milord, that is also considered. Milord Milind Patel. Otherwise, whole afternoon I'll keep hearing you should have cited. You have 3C paragraph 25 and 26. Relied upon and referred to material following Takano. And 26. Lord, whatever you rely upon in the show cause must be given is 25, and 26 is all documents which are necessary to undermine the allegations in the show cause notice must be supplied. That's paragraph 26. So inculpatory, exculpatory documents, the distinction was drawn. In this case, the declaration of which we don't have a copy, which is before the show cause notice, falls foul of Rajesh Agarwal. In fact, it's an identical case with Rajesh Agarwal, where where banks had proceeded without giving opportunity or without adhering to Article 14 and natural justice, they're gone. Secondly, if after the declaration falls foul of Rajesh Agarwal and is non-est, doesn't matter what steps you have taken subsequently, the declaration has to go. Number 2 is the show cause. Show cause after declaration has the effect of waiving the declaration. But if your lordship sees the language in the show cause notice, it proceeds on the basis of given a declaration. Now you tell me whether this is valid or not. It can't stand. However, if your lordship, the show cause should also go, they should give us a proper show cause notice. Because even if kept, the show cause would fall foul of the law because the show cause notice has to state the consequence of failing to show cause. Consequence cannot be upholding a previous judgment. by the show cause issuing authority. So on that logic, my lord, the show cause should also go. But if the show cause does not go, in that case, Lord, from documents onwards, the procedure in all these judgments, my lord, may be followed. These are my humble submissions.
Yes.
Yes, my lords. Now, my lords, there are, my lords, two facets to this controversy.
I'll come back into it.
Yes. Now, my lords, there are two facets to the controversy here. The first facet, which Mr. Chaudhary has argued, is that the procedure for declaration of fraud, as per the master circular and as enshrined in the judgments of the Supreme Court in Rajesh Agrawal and this court, has not been followed. So that is one part of the controversy. The other part of the controversy, which was not really touched upon, but which also arises in this case, is the subsequent actions which have taken place pursuant to the declaration of the fraud. Now, Mr. Chaudhary didn't really advert to it, but your lordship on your board have an application numbered as CAN 1, which has been filed by the petitioners. May I request your lordships to take that application first, because that is also on record.
Can't deny. কি দিদি ক্যান পাচ্ছেন না? এগুলো আনিয়ে রাখেন না কেন লিস্টে? বারবার বলছি লিস্টে যেগুলো থাকবে সেগুলো। What is it that you want to refer to?
Yes, now, my lords, I wanted to tell your lordships, even though the CAN may come later, but your lordship will take it from me. The other side will have it is. In the CAN application, the petitioner state that pursuant to the declaration of fraud of the petitioner, and they say so in paragraph 5, there is an FIR which has been registered by the CBI against the petitioner. The petitioners further say that if the source is bad, namely the declaration is bad, then the consequential action, namely the registration of the FIR, should also be quashed. That is what they say. And ultimately, the petitioners, and I'm not reading everything, but your lordship will only take a note of the prayers at page 47. They seek leave to add the officer in charge of the police thana, and they also seek a declaration that the FIR registered by such officer is illegal, unconstitutional, null and void, and necessary directions for setting aside the FIR should be passed. This is the prayer in the CAN, and your lordship will take it that this prayer is premised on the basis that because the fraud declaration is bad, therefore the consequential action must fail. So that is the second part of the controversy. Let me first address the second part, because that is a little important. Your lordship, my colleague will pass a judgment of the Supreme Court in a matter called, which is a recent judgment after Rajesh Agrawal, called CBI versus Surendra Patwa.
But may we clarify, my lord, that we've not pressed this point. We've sought for the setting aside of the declaration and the show cause.
He is giving up that point.
So your lordship may
He's not
record that.
pressing the can.
Yes, no, so then that should come out very
Not
clearly.
pressing the can.
Whatever consequences will follow, for legal consequences, we must have the right to take appropriate steps. That is lordship our submission.
No, I have a problem with that. Your lordship will first look at the judgment and I'll then address the point, because there is something surprising, a little strange here. Now, let's kindly look at paragraph 2 of the Supreme Court judgment. At page number 4, your lordship will find the page numbers bottom right corner. I'm at page 4. May I read it, please?
Yes.
Reserve Bank of India issued the master directions Master directions had been formulated with the objective of providing a framework for banks to enable early detection, reporting of frauds, consequently taking actions. In view of the same, appellant's bank initiated administrative actions that affected the respondents by declaring the company's bank's accounts as fraudulent, action which had significant consequences delineated in the master circular. Appellant banks also initiated criminal proceedings against the respondents with respect to fraudulent activity that was detected, as the master's directions required the bank to refer certain category of cases to the state police or CBI as general rule. Aggrieved by the same, respondents approached different jurisdictional high courts, challenging the validity of master directions and the actions taken subsequently. Now, please see paragraph 3. High courts, while the impugned orders, now please mark this, have quashed not only the administrative actions initiated in pursuance of master directions, but also the FIRs registered and subsequent criminal proceedings initiated against the respondents, placing reliance upon the ratio of the judgment of this court in State Bank of India versus Rajesh Agrawal. Administrative actions were quashed primarily on the ground of non-adherence to the principles of natural justice, more specifically the principle of audi alteram partem, as the concerned respondents were not given an opportunity of being heard before the company's bank accounts were declared as fraudulent blacklisted. May I just pause here? Exact challenge here. They say that even though you have blacklisted me on 7th of April 2022, the show cause notice came on 26th December 2022. So therefore, no opportunity of being heard. High Court's, I am reading further. High Courts consequently quashed the criminal proceedings initiated against the respondents, holding that they are a natural corollary to the administrative action of declaring the aforementioned bank account as fraudulent. And your lordship, my lords, will now come to the analysis of the Supreme Court at page 7, which is titled under the heading discussion. Your lordship will see on the next page, page 7.
Yes.
The first line, we would like to reiterate that in administrative action, criminal proceedings stand on different footings. Now, please see para 7. It's important. FIR, by taking cognizance of an offense, merely sets the law into motion, nothing to do with a decision on the administrative side made by a different authority, merely because the facts are same or similar. One cannot say absence of valid administrative action, no offense which is otherwise cognizable can be registered. At that stage, one only has to see the existence of cognizable offense based on the FIR registered. I am not reading the next few lines, but may I read paragraph 8, please? Foundational facts may well be the same, even in a case where an FIR is registered based on administrative action. Setting aside the latter on a technical or legal premise would not ipso facto nullify the former, ultimately a matter for investigation by the appropriate authority. When an administrative action is set aside on the ground of non-compliance of a legal necessity or mandate, facts mentioned thereunder could still be the basis for registration of an FIR. Hence, the high courts have failed to take note. And then Rajesh Agrawal is quoted, and paragraph 10 is where the Supreme Court says that principles of natural justice are not applicable at the stage of reporting a criminal offense. And ultimately, the conclusion comes in paragraph 12 onwards. There is only one line which I wanted to show. Your lordship will come to page number 13. And page number 13, your lordship will note that there is a quote from an earlier judgment called Canara Bank, which ends, and there is a line just before paragraph 13, which says, hence we clarify, there is no bar on the RBI or the complainant banks to proceed afresh.
Page 13 is the chart.
Actually, page 14 is the chart. I'm sorry. Page 13, your lordship will see bottom right corner.
No. Page 13, the copy which has been handed up to me, page 13 contains a chart which
I may have
I'm sorry. Page 14 also. Page 11, my lord. Page 11.
Well, I'm sorry. Maybe we have different copies. I'm so sorry for that. It's just one line above paragraph number 13, which actually says that we clarify there is no bar on the RBI or the complainant banks to proceed afresh by adhering to the principles of natural justice. So now, my lords, this judgment, and ultimately the table is what the Supreme Court did in various matters. Now, lordship will keep in mind two important points here. One, that just because an administrative order of declaration of fraud is being set aside on the ground of violation of principles of natural justice, that automatically does not mean that the subsequent action of registration of complaint must go. These are two independent things. One doesn't follow the other. And the other important principle is that even if the court finds fault with the process of declaration of fraud, the bank has the legal right to reinitiate the process in accordance with law. So there is, in that sense, there is no res judicata on the bank. The bank can do it afresh. Yes. Now, Malos, now please apply these to the present facts. Your lordships are being told in this case, the facet one of the controversy, that even though the declaration happened on 7th of April 2022, the SCN came 2.5 years later on 26th of December 2024. So the first argument is that the master circular is not followed. Rajesh Agarwal is not followed. There is a post facto declaration of fraud. There is no prior SCN. That is a matter of fact. I can't run away from that. As a responsible officer, I must say yes. So there appears to be some problem with the process being followed in terms of the in terms of the declaration coming first, the SCN coming later. But that does not mean that if any FIR is registered in this case, that should automatically go. Now, that is why they filed a CAN. The purpose of filing of the CAN was that let's get the fraud declaration out of the way, and automatically the FIR will also go. Now, today my friend says he is not pressing the CAN. Now, if he is not pressing the CAN, that must be recorded very clearly, because we don't want a situation that in any other litigation, the petitioner says, oh, the legal implication of this honorable court setting aside the order of the fraud is that the FIR must go. Your lordship it's my request. Lordship may record my submission based on the judgment of Supreme Court that even if the order goes, whatever subsequent steps are there, those will automatically not go. If he has any other relief to pray for, he's at liberty to pray for those reliefs. That is one important submission I wanted to make. The second submission is, my lords, that there is some confusion that the petitioners have sought to create regarding document supply. Now, my lords, the law is, the master circular says that you must give a SCN. The person concerned, the noticee, has the obligation to respond to the SCN. And thereafter, the bank will, after considering the response, pass a reasoned order. That is the mandate of the SCN. In Rajesh Agarwal, the court had read into the erstwhile master circular. There is now a new master circular. The Supreme Court said audio alterum partem must be read into the circular because the prior circular didn't have it. The new master circular of 25 already has the requirement of audio alterum partem. So therefore, we are required to hear him. The concept of furnishing documents actually does not come either from Rajesh Agarwal or from the master circular. It comes from the judgment of this honorable court by Justice Mukherjee, which was pointed out, which is 2nd of February 2024, which I had the occasion to also argue and address this honorable court. What the judgment says, and kindly come back to paragraph 64 of that decision. That's at page number 19.
Yes.
Now, my lords, your lordship will take a note first that Neptune and Rajesh Agarwal are considered in paragraph 63. And then the discussion comes at 64. What is the requirement now? The requirement is a show cause notice is to be issued enumerating the exact offenses alleged against the borrower director. If any FAR or other document forms the basis of the show cause, same is to be served along with the show cause notice. Now, please mark something in the bracket there, which was not read. Both the said criteria have in fact been satisfied in the present case in respect of BOI, BOB, and UBI. What was satisfied was the forensic audit report prepared by KPMG was handed over to the petitioner. So in the first step, there is no requirement of giving anything other than the documents. In the first step, the documents actually come from paragraph 65. May I read that? Fortnight thereafter would be ample time to give reply to the SCN. In its reply, noticee shall, apart from addressing allegations and controverting those specifically, specify the documents which are required to be provided to the noticee by the banks. If necessary in the reply, they can reserve the rights to give a further additional reply. Paragraph 66, the banks can give an inspection if voluminous and furnish copies of documents. So at the first stage, which is a criteria that the court found to have been met, is that we have to serve them an SCN and we have to give them a copy of the forensic audit report. In this case, in the case of I'm sorry, my lord. Your lordship had a question for me?
Yes, it was not only the forensic audit report, it says such other document that may form the basis of the show cause. It's not only
Correct.
FAR.
So, my lords, that the
If there is
reason,
another document which forms the basis of the show cause notice, then that also has to be supplied. That is what the judgment says.
yes. Now, my lords, your lordships are right. Sir, the reference to some other document forming the basis of a show cause notice is a reference to an audit report itself. Because this
May not be,
expression
because
actually,
it says if any FAR or other document. It may be forensic audit report, it may be anything else also. It depends
Malas,
on
your
what the
lordship
nature
will
of the
have
show
to,
cause is.
Malas, may I answer that? Your lordship will have to see this in light of the master circular. The master circular requires that prior to the bank issuing a show cause notice, the bank has to commission some sort of a report, some sort of an investigative report. That is a forensic audit report, or there may not be a forensic audit report, but there has to be some document requiring the bank to issue the FAR. And that is what is meant by this. In fact, this understanding, your lordship will see, is also there in the order of 9th of August 2024 by the same judge. So I think there is no real dispute, neither in this judgment, nor in the subsequent order of 9th of August 2024, nor in the judgments of Justice Krishna Rao which are handed over, that at the first step, we have to give them the SCN with the FAR. Which is why your lordship will note that in the bracketed portion at paragraph 64, it is stated that these have been satisfied. How they have been satisfied is by giving the audit report. It is even the petitioner's case. Your lordship may ask the petitioner that insofar as paragraph 64 is concerned, whether they were given anything other than the audit report. The answer will be no. Your lordship may ask them. It is actually for them, because your lordship will see in a real life scenario, I have a FAR. It is for them to tell me what all documents they need to give a response. I can't think on my own what all documents are required. So the original source document is the FAR. Your lordship, in this light, may I request your lordship to in fact see the judgment, the order of 9th of April also, 9th of August 2024 also. Your lordship were given that copy.
Yes.
Yes. Now, this was a consent order, and your lordship may come to paragraph 4 of the order. May I, read paragraph 4 of the order?
Yes.
Yes. Now, may I read paragraph 4. On July 12, learned counsel for the petitioner, learned counsel for the sole respondent in each of the writ petitions had submitted that the present writ petition shall be governed by the order passed on by this court on February 2, 2024 in connection with WPA. Sought time to come back. Now, please see paragraph 5. Learned counsel for the petitioner submitted that volume 4 of KPMG forensic audit report containing the annexures and exhibits to the KPMG forensic audit report have not been supplied to the petitioner. Learned counsel for the respondent banks does not agree. However, with a view to give quietus to this issue, has agreed that the counsel for the respondents would again provide a full copy of the FAR along with all volumes of KPMG report to the counsels for petitioner. And look at the dispositive portion at paragraph number 7. Although the respondent banks have served a copy of the KPMG forensic audit report to the petitioner, respondents bank through counsel will serve a copy of full KPMG forensic audit report along with all volumes of annexures and enclosures to the petitioner by August 10. And please see paragraph 8 now. Petitioner would furnish his reply to the SCN within 21 days from today, indicating the documents which are required to be inspected furnished by the petitioner. This is actually a consent order, that once I give them the full copy of the KPMG FAR, which incidentally was given, there is no dispute about it, they are then obliged at paragraph number 8 to give a reply to the SCN. And in the SCN, in the reply to the SCN, they'll ask for further documents. Your lordship will now look at the judgment passed by Justice Krishna Rao recently. Same understanding. May I just show that judgment was read as being against me, but the understanding that at step 1, it is only, we have to only give them the KP, the FAR is captured there as well. So Lordship, my lords, will take the Punjab National Bank order of 10th of February of this year.
Yes. Yes.
Yes. Now, my lords, your lordship will just, my lords, kindly come to the dispose. I just want to show the reasoning of the court. Yes, kindly look at, my lords, paragraph number 18 at page number 6.
Paragraph 18.
Paragraph 18 of the Punjab National Bank order, my lords. Paragraph 18, page number 6.
Page numbers won't match because you may be looking at some other copy. I'm looking at the judice copy. It's page 15, paragraph 18. If it is paragraph, the paragraph also matches. It's at page 15 of the judgment that I am holding.
My lords, does the paragraph say details of documents which the petitioners have
No,
requested?
no, no.
Oh, I
Paragraph
see.
18 is not that.
My lord, I'll hand over a copy.
Your lordship may take the other copy. I'm sorry, we have the copy which is, my lords, available from the website of this court.
It's the same thing.
My lords, your lordships are looking at, my lords, the Punjab National Bank. Is it WPA number 13100 of 2024?
Yes, yes.
Hemant Kanori and another versus Punjab National Bank?
Details of documents. Yes.
Yes. Now, my lords, kindly see the details of documents which the petitioners have requested to supply for submitting reply to the show cause notice are as follows. And there is now, your lordship will see a detailed list of documents which they ask for. Now look at paragraph 19, where the learned judge extracts the judgment in the earlier matter of 2nd of February 2024, Hemant Kanoria. After the list, paragraph 19.
Paragraph 19.
Yes, is the extraction. And please see now the view of the Honorable Court. Para 20, petitioners though have requested for supply of various documents, but in the said reply, petitioners have also indicated why the said documents are required. In their representations, petitioners have categorically described the relevancy of each and every document. Then the court holds in para 21, in the impugned order, respondent has narrated the total reply. Committee of the bank have also given their views on each issues, but have not given any reasons as to why the documents which the petitioners have requested to supply is not relevant, or the said documents have been supplied. At the end of the impugned order, committee has given its views, wherein in one part it is recorded said documents are beyond the forensic audit report. In other part, it is recorded that allegation of fraud detailed in the SCN are based on transaction, and these are record so and so. Paragraph 22, specific case of petitioners, entire documents of FAR are not supplied to the petitioners. And may I just skip the rest of it and only take your lordship to paragraph 23 and 24. Considering the above, court finds that petitioners have specified documents which the petitioners are required to give proper reply, but without any reasons and without considering the request, respondent has passed the impugned order. Thus, the impugned order is set aside and quashed. Respondent is directed to supply documents as requested by the petitioners in their reply of 22nd of May. So the point that I'm trying to make is, it is for the petitioners to ask for documents. I will only give them the FAR. What the court in this case, Honorable Justice Krishna Rao found fault with was that even though they had asked for documents, and explained the relevancy, in their reply, I had not given them the documents. Now, please contrast this with the present case, the case before your lordships today. In this case, there is no requisition for documents. And it is an admitted.
With the show cause notice, have you supplied anything to them?
My lords, the FAR is required to be supplied. Your lordship has already seen the order of 9th of August 2024. The KPMG FAR is already with them. The order, my lords, and my friends will not dispute it. The order of 9th of August 24, your lords.
The suit challenging it. But it is the forensic audit report is with me.
Correct.
Lord, when he says that.
So therefore, it is not in.
If you require any other document, why don't you ask for it
I will.
in reply to the notice to show cause?
Milord, there's no reason to argue, Milord.
No, correct. So
What
therefore,
about this can, what are you?
Can, Milord, I didn't even press it.
Yes, so that was his worry. That
Milord, but if your lordship sees the judgment, I am not asking for quashing, Milord, of that. Kindly, Milord, take the judgment, Milord. which my learned friend has
No,
handed up.
just a minute, let him complete.
Yes.
I don't know whether it is.
Yes, yes. So yes, now my lords,
Perhaps we can cut it short because he wants me to ask for, he says, number one, I have the audit report. I agree, I have the audit report, though not in connection with the notice, but otherwise, but that's good enough. Number two, he says that if you require any document, you write to me before we proceed. I agree, I will do that. Though he was supposed to give it to me, but I don't mind, I'll write to him to cut it short. Third, he says that the criminal case should not be quashed. I also say that it should not be quashed. I'm not pressing the can.
so there is largely an agreement. May I just, my lords, therefore not waste more time of this court. So, my lords, the first point is that the FAR is already with them. So that's a fair understanding between us. Point number two is both of us agree that if he wants any documents to be supplied to give a response, then, my lords, the judgment of 2nd of February 2024 should be adhered to, and that is already a judgment in place. So he can write to us, seek whatever, but before that, he has to give a reply. In the reply, he will indicate whatever documents are needed. That's the
similar in
judgment.
the first judgment, my lord. Point number two. I'll do that. I have no
Correct. So
difficulty.
he can give a reply pointing out whatever
That's
document.
indicated in the judgment which has been relied on by both of you, where he would file a reply, ask for documents, reserve his right to file additional reply.
Correct.
That's what
Absolutely.
is there.
Absolutely. Insofar as point number three, even though the can is not pressed, I understand that. But whether or not a can is filed, it would be my humble request to this honorable court that that principle of law, that this judgment of today's order will not come in the way of any subsequent action, should be recorded.
My lord,
Because
I'll record it as your submission because this I cannot decide that if it is not argued. If
Your
a
Lordship, they
point
may
is
not have
pressed-
argued it.
If a
Yes.
point is not pressed, Mr. Diwan, I will only hold something if something is contested. Now, something is not proposed. How can you contest it?
Yes, my lord, may I-
He has not pressed this can. I'll say that this can was filed. This can was filed, but it is not being pressed. I will record your submission that in any case, it is your submission that in terms of such and such.
and parties
Great
are
point.
free, my lord,
Great
to
point.
agitate whatever they want to, wherever
do
they
that.
want to. But
We
if
have-
your lordship looks at the judgment, this judgment
Which part?
on quashing, what had happened was that in several matters, when High Courts had not quashed the
Yes.
declarations which were contrary to Rajesh Agarwal, FIRs had also, my lord, been quashed consequently. Though, my lord, in those writ petitions, no relief in that respect was my lord, made. But if your lordship reads, my lord, the last 5 pages, they've all been remanded back. That's what I saw in the last 2 minutes. They've been remanded back for consideration. And in some of the cases, we find, my lord,
But in any case,
I'm
Mr.
not even
Mr.
going
Chaudhary,
into it.
it is clarified that there is no bar in the banks to proceed. If you want to get us an FIR quashed, you have proceedings.
I have proceedings. So, Milord, all the time saying, Milord, please don't prejudice him or me in the criminal matter. I will naturally
I'm-
go and say.
We have already, spent more than
More
an
than
hour.
one time.
So I think for dictating judgments, I will not take it today. I'll take it on any other day which is convenient to all of you. So that if you have anything to add, or because
Yes.
I'll be having a truncated day today, have a division bench in the afternoon.
Any-
So I'll
any
go off
day,
with
Milord.
some motions.
Any day, Milord.
Tell me.
Milord,
Mr. Diwan and Mr. Chaudhary, please let me know when next week I'll.
20th is okay with me. Well, if 20th works for your lordships, 20th of February.
20th will be difficult. Not 20th, any day except 20th. 20th again we'll have division
19th,
bench.
Milord, if we can come there.
Well, 24th would lordships 24th, my lords.
24th? Yes. 24th is
Oh,
not.
I'm sorry, Milord, I'm not there.
24th or
24th, we're not
25th.
there. But
25th.
since your lordship has heard the matter, I was hoping, Milord, for a shorter date. 24th is 10 days away. Milord, perhaps next week, next Thursday, next Friday.
Friday will be difficult
Next
because
Thursday?
Fridays are miscellaneous days. We'll have broken
Yes,
bench
I
days.
understand. But next Thursday.
I'll have division bench again. So
I have one, Mullahs, I have one request. Mullahs, on 19th, would your lordships, this matter will come up in the pre-lunch session, or Mullahs, would your lordship can even take it up post-lunch?
no, 19th again, 19th and 20th, Thursdays and Fridays we have a lot of miscellaneous benches. So if we
Agreed.
want to have it, we'll have it within Monday to Wednesday.
Monday,
Monday
Then
we can
Tuesday,
have it.
Manoj, may I request for Tuesday?
I'm not there on Tuesday. Monday,
So then
Milord,
Monday. Manoj, Monday is all right. I will not come in the way. I'm
Monday
sorry, we are
16th.
taking.
Monday 16th, Milord. Any time of your Lord.
Monday,
Yes, we'll
Monday, as a continuing matter, it will be at the
Yes,
we'll
Milord, grateful. Milord.
finish that way. We'll finish this off.
Yes, yes.
Yes, I'm so deeply obliged, Manoj. I'm very grateful for a very patient hearing.
I am recording that you are not pressing that can today.
Yes, yes.
লিখে নি সে থাক এটা আগে শুনে নি ওটা সিরিয়ালি থাকবে এইটা যদি সিরিয়াল মানে ইয়ে থাকে
Milord, I'm not pressing the can, and Milord, reserving my right to, Milord, raise the issue before the appropriate forum in accordance with law.
that is his submission. I'll record that.
Your Lordship may record his submission and your Lordship may record my
I'll
submission.
record your submission on the next
Yes,
day
very
because
well.
that will be a little longish.
Very well, very well.
লিখে নিন or for the sake of fairness I'll record at least 2-3 lines so that you are also satisfied.
I'm so deeply obliged, Manoj.
Heard Mr. Chaudhary, learned senior advocate, appearing for the petitioner, and Mr. Diwan,
Yes, Manoj.
learned advocate, appearing for the respondent bank. Full stop. Mr. Chaudhary, learned senior advocate, appearing for the bank, at the outset submits that he is not pressing can 1 of 2025. Full stop. Can 1 of 2025 is therefore dismissed as withdrawn. Right?
Yes, Milord, with the liberty to upload, raise the
not
issues
pressing can 1 of 2025 and his clients would reserve their rights to take appropriate steps in accordance with law. Full stop. Can 1 of 2020 না তারপরে লিখুন Mr. Diwan, learned advocate, appearing for the bank, submits that in any case the prayers made in can 1 of 2025 could not have been allowed by this court in view of the judgment of the Honorable Supreme Court in the case of Central Bureau of Investigation versus Surendra Patwa and others, reported at 2025 SCC Online SC 934, wherein the Honorable Supreme Court has held that a paragraph 8 টা copy করে নেবেন. The foundational facts may will be the same such and such. Paragraph 7 and 8. ঠিক আছে. Full stop. That's it, Mr. Diwan.
Yes, yes, yes. I'm so deeply obliged.
That
Yes.
should
Yes,
suffice.
yes. Correct.
If you want to add anything, you add it on the next day. I'm keeping it on Monday.
On Monday.
For continuation of arguments on the main matter, list this matter once again on February 16, 2026.
grateful, Milord.
So deeply obliged.
Thank you. এটা রেখে দেবেন, হ্যাঁ, ওটা ওই জাজমেন্টের যে ফাইলগুলো করবেন তাতে রেখে এই এতগুলো জাজমেন্ট এটা রেখে নিন, পড়ে যাবে. Yes.
Or my lord, I am for the
You
petitioner.
were supposed to add them parties and serve.
I have had them.
Served.
Yes. And my lord, my lord, speak the matter on 6th February.
Yes.
How the my lord, the matter appear on 30th? I do not know, my lord.
Oh.
And the matter was appear
Ah,
on
that's
first
it.
matter in presence of the state advocate. But on
6th
30th, they have not mentioned the same.
30th এলো কি করে দিদি?
6th February, the
6
matter was
তারিখে?
fixed.
Right, you are absolutely
That
right.
you have I have not appeared.
Very well.
But it was the duty of the state advocate to remind your lordship
No, it was my duty also to look into the order.
No, as your lord, I can't say, my lord. It is the duty of the other
It's
advocate
my
also.
mistake also. Where is the, that is why I don't dismiss it on the first occasion, because there may be a mistake on the part of court also.
Yes.
I always keep it under the head.
Written Mala, your lordship can fix the another day. As your lordship,
Liken in. This matter is appearing under the Disposed. Next. দেখে নিন দিদি ভুল ভাল appear করছে ম্যাটার গুলো একটু দেখে নিন। Not today, not today.
Dr. Item number 997, I am appearing on behalf of the petitioner, Lordship. This is my application that has been taken out on my instance. Lordship, during the pendency of the writ petition, Lordship, the petition number 3 has passed away, Lordship. So, this application is for striking out his name. His legal heirs are not interested to proceed in the matter, participate in the matter,
This-
Lordship.
Where is that application? Yes.
Lordship, the can one.
His legal heirs are not
They
interested.
are not interested.
So what is this matter about?
Lordship, this matter, we are challenging the process through which a sale certificate was executed by the ROR department, the Refugee and Rehabilitation Department, Lordship. I'm led by Mr. Banerjee in this matter, Devanik Banerjee, Lordship.
Very well. লিখে নিন তো।
So Mr. Chakraborty requested me, he's on his leg now.
Yes.
His junior is here, Madam.
লিখে নিন।
रही है? कौन सा?
হ্যাঁ, ক্যান তো আগেই ডিসপোজ অফ হয়ে গেছিল, ক্যান ছিল না, ক্যান আসছে কেন? ক্যান তো আগেই বলা হয়েছে যে ওটা ট্রিটেড অ্যাজ পার্ট অফ রিট পিটিশন, তাহলে তো ডিসপোজ অফ হয়ে গেছে না। লিখে দিন, since by the order dated January 30, 2026, the can had already been treated to be a part of the writ petition, the same should also be treated as having been disposed of. দুটোই ডিসপোজ, এটা দিয়ে দেবেন আজকে। হ্যাঁ,
Lordship, tender employees.
Andhra Pradesh not Arunachal Pradesh. I'll come back in 5 minutes.
Lordship, yesterday order
At place 3, I have distinguished 3 only.
Very well, whatever. After the 226(2) application by your lordship and the order of the coordinate bench, my initial points does not merit at all.
No, I have a duty. Whenever a point is taken, I have to deal with it.
May it please your lordship.
You want your name to be recorded? এটার নাম দিয়ে দিন না, কে চলে গেছেন নাকি? দিয়ে দিন নামটা, give it.
Well, this is that matter my learned senior friend is addressing. I pointed out that on this against the same notification, another matter is going on before the Honorable Ponji bench. And that's why your lordship directed them to add respondent the Registrar General. They have added the Registrar General.
My
is
lord, Mr.
also
Sholi
appearing.
Chakput is appearing on behalf of the registrar.
And now the question is, your lordship said that your lordship will be waiting on the last occasion for the outcome of that.
Yes.
Lord, we only prayed for leave because High Court's presence is required. High Court has been added. But a point has been taken that since a similar issue is pending before a division bench, which is taking up Ponzi matters, your lordship should not hear it and we should go to that Ponzi bench. Now, my lord, on this par contra, I would like to submit. Lord, as per our writ rules, I could not only find out 2 provisions relating to the power of the honorable single judge to transfer a proceeding. If my lord takes up the writ rules once, under 2 circumstances only, it could be done subject to correction by my lord. My lord takes my book.
Well, subject to correction, I have not prayed for transfer.
Then that is the in effect prayer that your lordship may not hear it. It should go that. Then your lordship have to pass an order.
No, his alternative prayer was we should wait the outcome of
And
the.
they should proceed with the trial without having determination, jurisdiction. I should be convicted and I should wait for the outcome. That's the other submission.
Well, it was my responsibility to bring the fact before this honorable court. I brought it. After that, if your lordship wants to take up this matter on basis, I'm here to do the matter. Your lordship wants to adjourn it for the outcome of the honorable division bench, I am here to obey that. If your lordship wants to release it for assignment by the honorable chief justice, that is up to your lordship. I have to bring it before your lordship. I brought it. I'm ready with 3 circumstances.
Now, may I proceed? Kindly have a look at Rule 26 and not Rule 56.
দেখি
হাত পৌঁছবে না, এত দূরত্ব বাড়িয়ে রেখেছেন, কাছাকাছি আনতে হবে তো। Now, Rule 26, if my lord sees, see the next page, the last proviso perhaps, আর বই আনন্দ So your lordship will refer it to the division bench. Lord, that my lord's kindly got that Rule 26 last
Yes.
proviso. Yes, it will be in that page. My lord may refer it to a division bench, but division bench here would obviously mean the division bench having determination. Notification. Lord, this matter, it is no one's case that this matter is a Ponzi matter. It's no one's case. It has been said by the ED that the notification that we are challenging, that is under challenge before that division bench. Now, my lord, I will have to depend on the outcome of someone else's petition. Now, what if tomorrow he withdraws the petition? Tomorrow he doesn't wish to proceed with the petition. Tomorrow he gets it delayed. My adjudication will be defeated. As per Rule 26, my lord may refer it to a division bench. Even after issuance of a rule, my lord may refer it, but that division bench has to be read as a division bench having determination. Now, kindly have a look at Rule 56 once. Rule 56. The carriage of proceedings lies with me. It cannot be dependent on someone else's petition. He might not ever move the petition.
Rule 56, public interest litigation.
Yes, kindly see the last proviso. Even if an adversarial litigation is filed, if my lord feels there is public interest involved, your lordship may refer it to the public interest bench. So that has to be the bench which has determination to hear public interest matters. Now today we are faced with a situation.
What does propriety say, Mr. Chakraborty, if the division bench is in session of a matter where a similar point is involved? Should the writ court go ahead and hear it?
Lord,
What is
at the same time, my interest is also required to be protected. I am before your lordships.
What makes you feel that interest will not be?
It cannot go to that bench. It cannot go to that bench.
No,
under the rules, it can go to the division bench. Lord, this is a residuary matter. This is a specially assigned matter. Apart from the other thing,
assigned means not specially assigned by order. A bunch of matters for a particular.
I am carrying that particular
Yes, that
list.
I know. That list, it is to be treated as it is not specially assigned. There is a difference between a special assignment by order and a special assignment
to understand this difference, Lord, I am also carrying the other list by which the matters were transferred to other honorable judges. Kindly see the last paragraph. In case of a normal assignment, it will
again is in block.
That says that it will go back.
This
Yes.
is assignment in block.
In block. In block,
It is not that type of an assignment.
not a particular case. Now
Not
a
a
block of
particular-
matters
it's
were assigned to
different.
your lordships.
It's
Now
different.
today, if today your lordships decides that the division bench should hear it, or the matter your lordship will not adjourn it till the decision of the division bench. Now, my lord, I will have to depend on that litigant who may not wish to proceed. This is one. Second, if your lordship invokes powers under Rule 26, then it has to go to the division bench, which has determination. That means the division bench taking up Group 9 matters. This Milord Ponzi scheme, this determination was created after Milord from 2014, after this Saroda and MPS issues came up. Milord, that was an appeal. The matter was first an appeal from Justice Soumitra Pal's order before the division bench of Justice Chellur and Justice Bagchi. It was a mandamus appeal. We challenged that for MPS, greeneries. In that matter, my lord, a committee was formed and it was decided since bulk matters were coming, there should be an assigned bench which will take up the matters relating to Ponzi bench. It is no one's case that this is the Ponzi matter. Now, if my lord sends me there, Lord, I am just putting one question to myself, Lord, I understand what is troubling your lordship about the propriety that my lord may not proceed, my lord should not proceed. But now today, that matter, the litigant is not proceeding. But my rights are getting affected. Your lordship, my lord, under 26 can send it to the residuary division bench. My lord may under 56, if public interest involved, send it to the PIL bench. My lord, if my lord releases it, it will be assigned to another bench, having determination, honorable single judge. But it cannot go to a particular determination. But kindly considers one thing, a notification, suppose a notification is challenged before a particular judge, having determination in Group 5, let us say, and a PIL is filed. There was a notification sometimes back, government came up, Calcutta, Kolkata Corporation came up with a notification that houses will be painted in blue and white, there will be a tax subsidy. Somebody challenged that before the single judge, someone challenged that before the honorable PIL bench. Now the honorable single judge may transfer it that there is a public interest involved. Here there is no public interest involved. Now my rights are getting vitally affected. I can show your lordships that there is flagrant violation of law. Not a judge who is similarly situated like other judges thinks that he is the master of the roster, decides to pass a notification, picks up cases from one court and transfers it to another court. And I have to go to that court which doesn't have jurisdiction to get my case decided. Let us see the merit. Kindly seize the merit.
First, let me satisfied whether I should take this or not
Today, if my lord releases it, it will be assigned to another bench having determination.
Not necessarily.
Because Ponzi bench,
Justice will decide where this
I will
matter
be
is
losing a
going.
forum of appeal. I will be losing a forum of appeal. Now from the Ponzi bench, I cannot go. That's a bench of strength of 2 honorable judges. I'll be losing a forum of appeal. Where is the conflict? No, there is no conflict. I could have understood that the division bench is passed an order. I am asking your lordship.
If division bench had passed an order, then
There
there was
would
no
have been no
question of
question.
me hearing it again. There was
Or
no point.
yes, or I am asking your lordship to overturn that. There is nothing like that. There is no conflict. I am
Question
before
is
the
whether
court
I
which
should
has
also
determined.
go on proceeding when the division bench itself is proceeding in the same court, or I should release it for it to be assigned there. He has a point there.
No,
I
I,
record all this and then I release it.
no,
Then what is the problem?
that,
You're
Lord,
losing a forum.
I'll be losing a forum.
My lord, may I submit one thing? My lord, this case, why I have to say this, because I had to bring this fact before your lordship. Number one. Number two, any order passed in this matter or relating to this notification will have an effect on 106 pending matters as on date. My lord, it is not his own case alone, because he is not saying that my case cannot be transferred. He says that the transfer of entire 106, but kindly see, I have prepared a short list for your lordship. That what is the status?
Copy it. Copy it.
একটাই copy,
You are giving something to the court. You give it to me.
This is a list.
Give me a list. Should get a copy.
My lord, what I am trying to say that this notification,
But I'm not concerned about any other case.
so 106 cases will have the same effect.
No, even if you're not
Yes.
concerned, if I hold that the court doesn't have jurisdiction, it will in any case.
Not any of the court will hold that. Not any of the court will hold that.
What is his problem? My lord, I tell you, lordship, in a nutshell. This matter is pending consideration of framing of charge for last 4 years on some pretext or other in the trial court.
Then why are you not allowing us to move the matter before this court?
I am no one to
Then-
not allowed.
I don't have a
And
case. I
what is
don't
the
have a
status
case.
there.
My lord, they have
division
taken, my lord, the fact submitted by my learned friend with deepest respect may not be correct, because the matter pending before the honorable Panji bench has been mentioned by the litigant on several occasions. Even last week, they have even filed a supplementary affidavit. Served copy on me. The matter is in session. I can say that the court is in session. Court on the last occasion, even Mr. Abroto is leading in that matter. Mr. Devashishra is appearing for the state, and in that matter, all of them appeared, and the court, honorable court, said that they will be taking up this matter after finishing a punch up they are doing now in court. That court, the system of that court, they takes up one punch. First, they took up that Sharda matter, Sharda matter. Then that আমাদের কি নাম ছিল? Prayag matter. Then MPS now Pinkon. Thereafter, that matter will be taken up. But even the state expressed their agony that these matters are stand still, because now, as on date, because of tendency of these proceedings before this honorable court, all new matters are going before a single judge, that is the chief judge, who is having 7 determinations. So the chief judge is also overburdened the state appearing to the TPS.
You don't have any instance of a similar nature?
No
precedent on this?
No precedent.
Now, may I tell you what is the issue?
Man, on
The issue is,
Blood,
blood one, blood a notification.
If your lordship takes up, then only I will go.
Blood, I leave it to your lordships. I leave it to your lordship's wisdom. Whatever my lord pass the order, we will not accept that. But the issue is, blood, the central government, in consultation with the High Court, should designate a particular court of sessions as blood a judge for PMLA court. Now the central government designates 5 court of sessions of equal strength as the designated court. Now one of the court of sessions is named as chief judge, the others are named as 1, 2, 3, 4. Now the person who is named as chief judge, he considers himself to be the chief judge, being of the same capacity, not being the master of the roster. He started picking up cases from court number 4, sending it to court 3, court number 2, sending it to court 1. He says none other than me can decide a case. Everything should be filed before me, but I'll show from the notification it is filed before him. Lord, a court of sessions is defined in section 8 of the CRPC and section 9 of BNSS. It says, my lord, a court of sessions is for a particular area. Now, kindly appreciates this. A court of session of Calcutta. I am a court of session of Calcutta. He is a court of session of Lord Howrah. Both are equally placed. Now, can I now take up from his jurisdiction? He is not the chief justice. That's the challenge.
That is on merits, Mr.
Yes,
Chakraborty. I am sorry.
just to tell your lordship, just to tell your lordship.
That
So
is an
Lord, my case is that today, there is no instance that, yes, if there was a public interest involved, my lord not applying 56, my lord send it. My lord may send it to the division bench. But that division bench is another division bench of completely different from the determination that your lordship is having. I will lose a forum of appeal. Consider this, my lord, and I don't want to prolong these issues, my lord. Whatever my lord says, but I humbly pray that my lord takes it up, calls for a report, decides the matter. There will be no conflict.
There is no problem in deciding. The problem is the propriety in deciding.
Lord, in my humble understanding,
Once
I don't
this is
think that
brought
your
to the
lordship would be
notice of
stepping
court,
into the
then the
territory
same-
of the division bench.
the-
Your lordship is not going to step into the territory of the division bench. Division bench can take only Ponzi matters. I am not a Ponzi. Why they want to tag me? I don't want to.
This point is that is what he said exactly, that this is the point which has been taken.
Then
The same
suppose if
justification is in
if
challenge.
all 106 cases they challenges, all 100, this is a bank fraud matter, we have come in residuary. But suppose, my lord, there is some other matters which related to land and something like that, there is a case. But if that's challenge, although it should come under residuary, from all determination, it has to go to that bench. He says 106 cases, if 106 petitioners decides to come. But kindly considers this. It's at the nascent stage, division bench has only called for affidavits, no decision has been arrived.
No matter has been hard.
Is there any
stated
decision?
for 2 days?
Has there any,
Division, honorable division
can he
bench
show
has
any
requested
order?
us, ask the state to give a formulation how the matters to be distributed. State has given a report. Registrar General has submitted report. Man, it is not correct that division bench is not taking up the matter. Division is not doing the matter. It's not correct. I'm sorry to say. These are the facts.
Very well. Let me think over it. Can we have it on Tuesday or Wednesday?
Whenever, my lord, we are here every day.
Because
Barring 18, 19, 20, I want.
Huh?
18, 19, 20.
Oh. হবে 18, 19, 20 বাদ দিয়ে ভাই যেদিন থাকবে সেদিন করা হবে।
Real man on 18th.
ঠিক আছে।
18th will be difficult. We have a lot of in the next week. I mean, week next to that, week beginning 23.
23, yes, 20, 25.
25 we can have it.
No, let him check his diary. I have no diary. I'm here every day.
No,
Whenever my
because
lord
you have
says-
that digital thing, so you will not have that.
Whenever my
Diary
lord
for
will
lesser
come.
mortals like
Will
us.
come, will come. Whenever my lord gives it.
No, whenever you all decide.
25th, he says 20.
Let me think of that.
Kindly consider this, my
The
lord.
thing which is troubling me is
Yes.
only I would have entered into merits, but then
My lord, merit, I can tell you, I have a very good case.
on Fridays, yes.
So, if your lordship wants, we can come back on
27th.
27.
27.
Just not to disturb the other days.
27th.
27. লিখেন into.
May I?
Yes.
বইটা
As jointly suggested by the parties, list this matter on February 20. Yes. এই বইটা ওনার দিয়ে দিন, বই রয়ে গেছে।
Paper. Judgment delivered.
Yes. Godfrey,
Okay, I have the
Mr.
opportunity.
Mitro is there.
I have the opportunity. Mr. Galib today appeared.
No, what is
I had a tough time in it because
Yes.
that issue was very troublesome. The presiding judge's absence, but somehow I could.
A lot of industry has gone into the making of the judgment. We have seen.
I don't know what is the
No, it
ultimate
has
worth of it, but then I found some sense in the sections of the City Sessions Act and getting it.
CTC
tolerated
Act
with-
also has been taken into consideration.
Yes.
Lordship.
And CRPC also.
Yes, because they give a line of an answer.
The Seriesville Act issue was not at all argued, but Lordship has consulted and.
Yes, because I was thinking of having some judicial basis of whatever I pronounce. Whatever I pronounce must have some judicial basis.
Lordship.
Merely because I think that it should be, it is not right.
Almost every minute detail has been taken care of.
This issue was never discussed in any other case.
Any
The
other
My lord has dealt with that.
Yes.
It's a new horizon. It was a new horizon. Grateful.
Thank you. Thank you to all of you, because it wouldn't have been because
Your lordship, Father.
yes, it was nice. It was a novel experience for me also, because I didn't have the occasion while I was on that side
No, Lordship.
to go through CRPC and sessions and all that. But it was nice.
Lordship.
It took a lot of time. Actually, I wanted to do it a little earlier, but then because of the research
Further
that I had
homework.
to undertake,
So many judgments on both sides.
both sides,
So that had to
and
be
both on the same point, deciding issues differently.
Hmm.
So facts of all the judgments I have, that is why I tried to,
Judgments relied upon are almost similar.
yes. So I have tried to sift the facts. In the judgment also I have quoted why.
Sifting the fact. Lordship.
Great.
Very enlightening judgment. But this issue, my lord, acha, might be the whole.
I am for a very short matter in this, my lord, the prayer, my lord, for return of the earnest money, but the facts remain. Lord, the e-tender has been called, my lord, for 8 ferry ghats. My client participated e-tender, all the document along with the all documents by the e-tender. Lord, on 23rd September 2024, only, my lord, a message, you are allowed to participate in the tender on the cause of the false document. This is the issue. So I could not participate. That is page 84. I am drawing Lordship's attention thereafter. What is it? Lordship, then things for a moment where my client could not participate in the tender process, then my client made the prayer for return of the earnest money. Now this writ application has been filed before Lordships only for return of the earnest money. Did not challenge that why my client could not participate in the tender process, that has not been challenged before this court. Now my learned friend filed a report. What report? Report has stated in paragraph 3b and 3 that a comparative statement for pre-qualification equivalent evaluation was held on 23rd September 2000. This has been main given. Lord, my respectful submission, what steps has been taken against my client? Why? Where there is a provision for pre-qualification evaluation, nothing in the agreement. Nothing in the agreement, e-tender agreement. I have annexed all the documents. The e-tender agreement says, if the person qualified in the highest bidder, after highest bidder, if it is failed to produce all these documents, then his earnest money will be forfeited. This is the question. This is the facts. My respectful submission, I have been prevented not participate in the e-tender process. So my candidature has not yet been considered. So I am entitled to return back the earnest money. That is the case. Lordship, kindly see, I drawing Lordship's attention just to Lordship's page 29.
Page 29.
Page 29. What I am submitting before Lordships? Lord, I drawing Lordship paragraph 8. Before issuance of the lease order, the auction inviting authority may verify the documents of the highest bidder if found necessary. If found necessary, after verification, it is found that such documents submitted by the highest bidder is either manufacturer or false, in that case, lease order will not be issued in favor of the highest bidder. Under any circumstance, an action will be treated as cancelled. This has been claused in the agreement. Now the report has been submitted that pre-qualification has been held. Why the pre-qualification has been held? Verification has been held. In case of my case, I am one of the participants, but I could not participate in the tender process. That is page 84, Lordship kindly appreciate.
Page 84.
Page 84.
Yes.
This is only payment approval status for auction with reference to the certain payment for the following. You are informed that your EMD payment has been rejected. Earnest money deposit, EMD, that is earnest money deposit, has been rejected. This is only message.
Just a minute, 1 minute. First page you showed was page 29.
29. The authority concerned cannot.
Page 29, then page 84.
Page 84.
Yes.
Page 84. Only the message.
It says due to false documents.
False document. When? On 23rd September 2024.
Yes.
Got your lordships? That is before holding the auction. That is also the, my lord, the VC, that is also the violated the own tender process. Today, my lord, got your lordships? I am just drawing lordship's attention their own agreement, which has been submitted auction agreement, page 29. I am drawing lordship's attention. They cannot violated their own circulation. Now the question arises in the report. My documents has been very pre-verified, the pre-verification. Why? Why the pre-verification has been done? As to whether any notice has been sourced, as so cause has been given, nothing has been done. Only the message is page 84. So all the things have been done in violation of the natural justice. I am not to that. I am not to that. Accepting to that page 84, I am entitled to get back the earnest money deposit. Today I am the BD application. I have not challenged my qualification. I can challenge. The time has already collapsed. I could not reach to the bidder. I am not could reach to the bidder. Since very inception, my very initial time, my payment has already rejected. So earnest money amount is lying with them. That should be returned back. This is a simple question. No so cause, no notice has been given to me before rejecting the same. Now my learned friend says by report that my earnest money has been forfeited. The forfeiture closure is only covered in paragraph 8, page 29. If I am participate as a bidder, then the question of forfeiture arises. I am not.
Yes, Mr. Galib. 3 points. One is that it has been done without issuance of notice to show cause. Second is that he has been singled out. Third is that singled out in the sense that only his documents have been verified prior to the auction process being concluded. And third is that the only clause under which you can forfeit is clause 8.
My lord, Lordship knows also, my lord, that in a tender process, there are two bid system. One is technical bid, another financial bid. Technical bid is a stage where, my lord, the documentation part is being evaluated by the tender inviting authority. So, which is in common parlance called pre-qualification
bid
or stage. evaluation takes place. If you qualify on the documentation front, then you will be regarded technically qualified bidder and you will be going on to the stage of financial bid. So here such is the case that there was a technical bid stage. His documentation was that evaluation of documentation took place. At that stage, it was found that the vessel license which he had submitted with his bid is found to have been forged document because we had cross-checked from this Calcutta Port Trust, because that was the issuing authority of that particular vessel license. Port Trust said, yes, this is the license which was not issued by us. So the moment we have cross-checked this particular vessel license, having been a forged document not issued by the issuing authority, so my lord, we said that your EMD, the earnest money deposit, stands forfeited since you are disqualified at the technical bid stage itself. Thereafter, what we did, he, my lord, prayed for, since he was no more interested in participating or going any further, naturally because he got disqualified at the technical bid stage, then he, my lord, shoots off a representation telling that give me, all right, I'm not interested, I'm disqualified because of this and that. You give me back my earnest money. In reply to that, the authority, the tender inviting authority says, okay, you come. I'm giving a hearing notice. Participate in the hearing. Show cause why did you supply or furnish this forged document for participating in the bid process. My learned senior friend's first contention that I did not participate in the bid. It is a wrong understanding of the tender ecosystem. It is a participation. He participated.
Show me the two stages if it is there.
Now, Miller, if your lordship, if I may respectfully invite your lordship to my report on affidavit used by the authority, Miller, in compliance with the lordship's Miller direction, Miller. If I may, Miller, respectfully invite your lordship, Miller, to page Miller 3, Miller.
Page 3. Yes.
In total, Miller, there were 7, Miller, notice inviting tenders for giving tenure of these ferry cards. Lordship will get the neat number, neat 15, neat 16, neat 17, 18, 19. Lordship will get from clause A of paragraph 3. The petitioner participated in all the e-auctions. And this is also corroborated in paragraph 4 of his averment in the writ petition that he participated. Now comes that evaluation of the documents. Lordship kindly see page 7 onward, the annexures.
Page 7.
Page 7, my lord, the bunch of documents, it runs up to page, my lord, 22.
Yes.
This pre-qualification evaluation, that is all the documentation part of evaluation took place of all the bidders. Kindly sees the first name Mojammel Rijaul Haq. The second name is SS Construction. SS Construction is the petitioner before your lordship. Vicky Sheikh is representing this SS Construction, and kindly see the remarks column at the last column of the page. Horizontally. False license document related to iron boat submitted. Now all other bidders, their evaluation also takes place. Kindly sees all these 1, 2, 3, 4. 4 bidders altogether. This is of one neat. Page 8, your lordship gets the evaluation of another neat with different auction ID number. In this way, mirror all through his vessel license document was found to be false. Now, what does the authority do? Authority, how does the authority come to the conclusion it's a false document? Lordship may kindly come to page 26.
Yes.
The tender inverting authority get is checked. Kindly see the mail. It is coming from Director, Marine Department, Shama Prasad Mukherjee Port. The license issued from 22nd August 2024 is a false license and has not been issued by the Office of Superintendent Board Registration under Marine Department SMPK. That is Shama Prasad Mukherjee. Superintendent is hereby directed to cancel the registration of the said boat. So this page 20. Where is this boat license? Lordship will get the boat license referred to, that is 22nd August 2024 boat license. Lordship will find at page 29 of the same report.
This one is the license which is
License
submitted by
kindly
him.
sees Majhi's license 224 with effect from 22nd August 2024, expire on 21st August 2020. Lordship got that at the middle.
Yes.
Yes. So Shama Prasad Mukherjee Mirror Port Trust say that this was not issued by us. Why was it given? It was the reply to page 27. 27 was the letter from BDO to Port Trust. Kindly sees the contents of the BDO's letter. This is to bring to a notice the undersigned invite e-auction for 8 ferry guards under the jurisdiction of Belnanga 2 development block. In eligible criteria, the bidder should have at least one large iron boat with the capacity of not less than 40 tons for the ferry service for long and big four-wheelers. During the process of scrutiny of papers submitted by different bidders in the web portal, so and so it is found the local bidder submitted document as vessel license for 2 consecutive years, which are having with effect from date so and so respectively. We have apprehended that the license having with effect so and so is edited. Photocopy of the license so and so. You are requested to affirm whether those licenses are issued from your esteemed organization. It will be very helpful if you send a reply at an early stage of finalization scrutiny so and so. So in reply to this port authority is giving the reply. So this is the scenario. Now comes that where from do you get the right? Lordship may pose a question to myself, may pose a question to me. But this honorable court, that where do we get the power of forfeiture of EMD from your need document? To be very candid as an officer of court, there is no such clause in the need document. That if any documentation is found to be forged of the intending bidder, found to be forged at the evaluation stage, you will face forfeiture of EMD or you will be blacklisted, as we usually find in all the tender documents. I checked and cross-checked with the authorities, the tender inviting authority. In all these 8 needs, Lordship will not find. Only one clause which my learned senior friend has referred to is clause 8. That is also different stage altogether. That is before issuance of this order. So there you can. Nonetheless, my lord, which my learned senior friend was telling, that without complying with the principle of natural justice, my EMD has been withheld. If I may respectfully invite your lordship, my lord, to my lord, page 5, my lord, report that I am referring to.
Page 5, clause F.
My lord.
Yes.
It says, my lord, the petitioner has deposited the earnest money in respect of all the ferry guards under the auction. But it is noteworthy the petitioner provided forged document and hence disqualified from the auction. On earlier occasions, explanation in this regard was sought and appropriate reply and communication have been made. But nowhere in the reply, it was mentioned that the EMD will not be refunded. So this is the authority's version. We had many interactions with you, but did you ever say that we will not be refunding the EMD? Such is not the tone and tenor of our communication by and between you and me. This is what he says. Now, my lord, if your lordship may kindly comes to clause G, what does it say? The application dated 18 December 2025 for refund, that was the first application by him for refund of EMD, was received. And in response thereto, A letter was issued therein replying to the queries of the petitioner and further seeking explanation in respect of the forged document with a memo number so and so through mail and by post. But no reply from the petitioner was received. Thus, the security deposit was held, not forfeited. Where is this letter seeking reply from him? That is, Lordship will find at page 138 of the writ petition. 138 of the writ petition. This is the 14 January memo which was sent by the authority to the petitioner. Page 138, kindly see.
138.
138, my lord. The last
Writ-
annexure of the writ
137. 14 January 2025. Writ petition.
In my writ petition, it is 138 marked. Last annexure,
14 January 2025.
Lordship.
Yes.
It is from video to the petitioner, Biki Sheikh.
Yes.
What does it say, my lord? Kindly see. This is to inform you that earnest money have been claimed through the letter dated 18 December 2024 of your advocate, so and so, against the auction. Documents submitted by you related with cargo vessel license zone are false on the ground disqualified. In this circumstance, you are requested to explain why not legal action will be taken against you for submission of forged document for the purpose of securing participation in the. You have to reply within 7 days. This was not replied to till date. Now, if this honorable court, my lord, is pleased to ask me a query that show me a clause wherefrom you have the right to withhold the money, I can't. If this honorable court is pleased to ask me a query that any forfeiture clause or blacklisting clause from the NEET, I can't. But, my lord, he says not forfeiture, he says in the report clause F and G that I am holding it. Never did I say in our communication between by and between you and me, never did I say I will not refund. But I am to need for explanation as because these people, they even when in future the ferryghat tender will be floated, naturally they will be the participants. But in that context also, there is no such clause that if you are found disqualified on the issue of forged documents submitted in earlier bid, you will be disqualified 3 years, 4 years in the next bid. Will not be. These clauses are totally absent from the NEET documents. But when the only Millard sheet anchor of the authority, which I am representing today, is my learned friend's client may comply with page 130, that is 14 January. Since this has not been complied with as per the report on affidavit of your lordship, this crisis or predicament as on date subsists. So, my lord, these are my NEET document with your lordship. The clauses are clear and report on affidavit. The tone and tenor of the authority. On oath, he says this. So he may go and participate, if I may.
Why don't you go and participate in the hearing and
Natural justice will
satisfy them? Take back your money.
My lord,
They have not yet forfeited.
my lord, think for a moment. My learned friend says an action has been taken. My lord, they kindly upset.
Action is only of withholding. That is on affidavit.
No. This is the last page, 137. Later dated 14 January 2025.
Yes.
Last line, your lordship, kindly see. In this circumstance, you are requested to explain why not legal action will be taken against you for submission of false documents. They have already decided to take the action against me. Why I will give the reply? I come before this honorable court. I come before this honorable court.
No, but
with
Mr. If an allegation is leveled of you having submitted forged documents, you come before the writ court. Can you satisfy the court that the document was not forged?
My lord,
because this is a court of equity also.
My lord, the only things for a moment. At the outset, I am submitting before lordships. I am not challenging my rejection. I am not challenging. Today, I am come before this court with the prayer for.
It becomes difficult.
Then your lordships kindly. The action taken my client against my client. If your lordships see the documents, reply. If your lordships, 23rd has been taken decision. 23rd September. why the 21st September they made the query before the other authority without verifying the documents? So
21st
personal action.
21st September has to be before 23rd because
No,
23rd is
no,
this is
certainly
this is
not.
the
Kindly
ticket.
appreciate. If it is the
Mr. Maiti,
pre-qualification,
on
my
24th
respectful submission, if it is the documents for pre-verification is required, that is held on 23rd September. Before that,
Mr. Maiti, you have to satisfy the authority that your document is not fake. Now, suppose, let me proceed on the basis that their decision that your document is fake is wrong. That decision itself is wrong. Your document is not fake.
Yes.
Now they have.
I am not participated in the tender process.
Whatever it
As
is.
because when my client was noticed that my candidature has been rejected, within time I can contest the same.
This is a court of equity also. You could have gone to a suit court and made this submission. It would have been
And
different.
reply to that, my lord.
Before a suit before
my
a writ court, if even before writ court, if you are not fair enough to say that no, your document is not fake, they have illegally done that. All the other technical arguments of it not being there in the tender process, power of forfeiture not being there, would have been immediately bought by the writ court. But today, there is nothing, no averment worth the name in the writ petition also where it can be said that no, the documents were genuine. The department's allegation or the state's allegation that the documents are fake and false are absolutely baseless. This is not the case.
If it is lordship, kindly appreciate. If I am satisfied with my document is genuine, then when learned friend says all the benefit will be given.
Definitely,
all the tender process is already done.
That is why they reply.
That is my lord the finance since I am standing in the air. If it is if I am challenged, the document is genuine, then the authority will give him all the benefits.
What benefits?
Benefits. I could not participate in the tender process.
You could not participate because you could not convince the authorities that the authority is not fake.
No so-cause was given.
Sir, you could have replied to it that your notice is wrong.
When so-cause has been given? After rejection. After rejection.
At the time of rejection, did you make any objection that your rejection is wrong?
My lord, the things for remind. When I made the prayer to return the amount, then the reply has been given. Then the reply has been given.
Before that,
that is totally afterthought.
Before that, you also
before
did
that
not
I could not chance.
Why not? You could have definitely said if you are interested in the tender because of the document on the basis of the originality of the document that you now project.
By this time, my lord, the valid period already expired. By this time, license valid period already expired. So I could not. I did not interested. My responsible submission only things for a moment.
Because writ court will not shut its eyes to everything, Mr. Maiti. Merely because there is some aberration, some technical fault, writ court will not do that.
No,
I will also have to do justice with the state. You come up with a false document. You don't make out a case that
I
the
am not
document is
with
false
the false
merely
document.
because there has been some technical violation at
I am not
stage.
saying. My lord, the things for a moment. My lord, the 7%, my lord, 7% participated in the proceedings. My lord, only my candidature has been verified. As to whether the other candidate is verified.
That is up to them. They can verify anybody.
No, before
even before.
My learned.
23rd,
before this court, that's why I'm placing your record before the court.
That is true. My lord, the kindly appreciate page 20. They have annexed the reply. My lord, all the decisions taken on 23rd September. But the 21st September, they made the query.
Yes.
In my case,
yes.
Not on my. I could understand all the participants.
They have to make the query earlier only so that they can arrive at a decision later.
Then
decision
I could
follow the.
No, this is my lord, the principles, my lord. All the participant query has been met. Then I could understand.
Must have been made.
No, certainly
even
not.
Even if it is
They
not
are
made.
stated.
I take it is not made.
Then that is personal action.
They ask you, are they not entitled to ask you?
No,
They are going to give you a tender. You will say that no, you can ask me only if you ask the others.
No,
that cannot be the law.
My responsible submission to that, my lord.
You will not take responsibility for the document that you are submitting, and you will find fault with them merely because they have pointed out that your document is false.
My lord, I am not challenging the document participation. Since my lord, my case has been rejected by thereafter no so cause has been given. No explanation has been given before rejecting.
That is what is making.
When I made the application for return
That
of
is
the
what
money.
gives rise to suspicion, sir. That is what gives rise to suspicion.
My lord, the only query is, my lord, when they have made the application, reply on 14 January 2025, when I made the application, return the amount.
This
Before that, they have not issued the
this,
notice.
anyways, when can we meet next? Not now. It's one.
Just
till
one
now.
word answer to your lordship's query.
I'll need time to dictate also and to.
May I come back at the
When can we have not
This 14 January, let them participate.
No
No.
question of participation. I shall explain, my lord. I shall
Who
explain
is
because
going to argue?
That-
Please,
that-
it's a protocol of the court.
No, no.
Maintain
My lord,
the decorum.
my learned friend says, my lord, when I come before this court, at this stage, it is not the case of the participate in the proceedings. When I come before this court in a writ jurisdiction, my respectful submission, only when I made the application for returning the amount, they have issued the notice 14 January.
very well.
Before that,
I'll fix it on say Wednesday or Thursday if you are convenient. All of it is convenient to both of you.
You are always lordship.
As
না, তোমাকে তো পাওয়া যায় না ওর লক্ষ্য মানে
3 দিনের মধ্যে আপনি আসে দুবার
হ্যাঁ।
আসেন। জানেন জুনিয়র ইজ দেয়ার।
Anyways,
দিদি একটু দেখে নিন মঙ্গলবার কিছু ফিক্স আছে তো সোমবার রাখা যাবে না সোমবার তো দুটো অলরেডি ফিক্সড হলো তাহলে গ্রুপ 4টা ঝামেলা হয়ে যাবে
Let it be on Friday, lordship.
Fridays I'll be
Division.
yes Fridays I don't want because ultimately like today
Thursday.
my lord, only one Indian, my lord.
yes
May I come with the supplementary affidavit? What documents placed before the authority by tender, e-tender?
they have filed their report you have taken exception to that
No, my lord, the super, your lordship's
again
query.
I will have to give this will again
No, your lordship's only query is that is the, my lord, my documents are genuine or not, which
that I
placed-
cannot decide now you could have then objected to it and thrashed it out
The question was, my lord, things for him, and this is the later stage.
because this decision is ultimately to be taken by the fact finding authority read court how will I decide whether it is
No, when your
right
lordship,
or wrong
when a lordship's query, when lordship's
my
query,
lordship my query is because your case in
14
the
January,
petition is not
14 January application, my lord,
that.
14
Your
January
case
later.
in the petition is also not that now I cannot give you chance to improve that you have already made your averments in the writ petition on the basis of that you proceed you have taken exception to the report on the basis of that you proceed
Yes, then your lordship.
yes মঙ্গলবারে অনেকগুলো নেই দুটো তিনটে ফিক্স করলাম
Your lordship was pleased to direct the respondent, private respondent, SEBI on 16th January to exchange affidavit within 2 weeks. But yesterday I got a voluminous opposition, my lord, with 3 volumes, my lord. I need 2 weeks time to wait, file the claim.
prepare it in the meantime prepare it I'll call it by that
Let it be fixed on 27th, my lord.
it will automatically be on 27th it is not going to be called today matter for what which matter group 4 I will not have determination for that land matter land matter I don't have I had at one point of time now I don't have determination it's only unauthorized occupants matter that matter is not for me to decide is land only group 9 or land not before this court
San mine.
either you go before group 9 court or group 1 unauthorized occupants acts only I have the I don't have determination How can I take 8? I don't have determination.
My lord, item number 874, my lord, can it be any other than 27? Because again, this matter will be listed.
874.
874. Today,
Problem is, let them not issue the, or rather enter into that sale agreement which I have got the order.
my lord,
That
today I,
here to pass an order then.
That's right. I am for respondent number 8. There is some difficulty, I'll come and tell you. Because we feel that
Today it won't be called on because to 2 p.m. I have different.
coming Friday.
coming Friday, next Friday. Next Friday.
Next Friday.
Directed and
No, Lordship,
not at the motion stage then.
So, Lordship, not at motion, but we had brought the can because in similar matters on this was the coordinate bench, Lordships, wherein it was written that it will abide by the decision of the writ petition, and when the order was passed, the court has stayed the proceedings until further. No recovery should be done because the court is in seizure of the matter, Lordships. It's a listed company, and the demands because of the inflated demands, Lordship, that is the issue there.
Give it.
914, Lordship. 914.
Kindly fix my day for the application whenever it is convenient to my lord. Applications I had fixed today, but When division benches come,
we did not saw the laws.
Remember that matter relating to excise where the department has upon CESTAT passing the
একটা
judgment.
কাজ করুন দিদি, সামনের সপ্তাহে না একদিন অ্যাপ্লিকেশন আলাদা করে নিয়ে নেবো, ওই ফ্রাইডে বাদ দিয়ে, ওই মিস্টার ইয়ের ম্যাটারটাও, মিস্টার শ্রাফ
913. Mr. Shah's
চেম্বারে এসে কথা মনে করিয়ে দেবেন, ভুলে যাবেন না। ওটা অ্যাপ্লিকেশন দিকে একটা অ্যাপ্লিকেশন, I'll be fixing it on a particular day when I'll be taking up applications in the coming week. So you will be taken up. So I'll be taking up in the coming week itself. Let me arrange my affairs also, because ultimately in urgent motions matters it will go at item 81. It may not be taken up by Tuesday.
Was filed last year.
So what? There are matters prior to that also. There are 2024 matters also as urgent matters.
They've never been taken up. That is why.
That all those matters were never taken up. All those which are appearing as urgent were never taken up. It's all motion stage. You want it to be taken up. It will be taken up next week.
The cooperative society, they are not able to pay the salaries to the people who are 250 families.
Maybe Tuesday, Wednesday, in between that only I'll fix a day for application. I'll have a word with Mr. Sharaf. I have said it. Let us see. Let me arrange my affairs.
My lord, my senior Mr. Vejjan is appearing online.
May I submit your lordship? This is a match. Item number 26 is regarding a writ petition against 148 proceeding. So, lordship, it is not reaching the board now. The assessing officer has issued a show cause notice today. So, my submission is maybe hard today or maybe your lordship.
And the show cause notice is hearing is to be held on 19th February. That is Wednesday next week.
And what have you challenged?
148 notice, your lordship. 148
Why? On what ground?
There are 4-5 grounds, your lordship. One for Jao versus Fao, of course, but there are other grounds also on the issue limitation.
So it is appearing under the heading adjourned motion. That means you did not get an interim order when the matter was moved at the first instance.
No, it was not. No, it was not taken up at any time, your lordship.
Not taken up.
Why is it appearing as adjourned motion if it was not taken up?
It's upgradation.
No. It's appearing. 46 is appearing under the heading adjourned motion. 26.
26, your lordship.
26. Inform the other side. Inform your other
given
side.
a service to him.
If they appear, I'll take up. Both sides are here. I can take it up today also, if it's that urgent.
But we have gone to Union of Ministers. We have gone to service and service. We could not find him because he's not picking up the
So
phone.
if the other side is not there out of turn, I'll take it up. Without ex parte, I cannot take it up.
But at any time next week, then anytime.
Bring any time next week your other side. I'll take up. I have said so.
Very well.
Maybe we will try to get him today itself also, lordship, if possible.
Call করুন.
Item number 3. We are under the impression.
You want to get upgraded?
No. Adjourned. But for
my lord had directed them to file a sub rejoin.
but that is not ready. My lord, I need 2 more days. If your lordship could take it up or extend the time and take it up on some other day.
Next Friday.
Yes, my lord,
Next
next Friday.
Friday may be difficult. Next to next. It will be 27th.
My lord. Very good.
Because again, division benches and all will be there.
Yes. 18th, your lordship has a division bench.
18th I have, 19th I have.
19th also. 27th will come back. Lordship may extend the time.
ওই 3 নম্বরে একটা অর্ডার রেকর্ড করে নিন।
27th NCLT হবে।
Mr. Surojit Dasgupta, learned advocate, appeared Reply. Plaintiff in GA1 of 20.
GA1.
Mr. Mojumdar has concluded his submissions. I was to respond. Please take up, my lord, the report in the form of an affidavit affirmed by the learned Registrar General.
Yes.
Please turn to page 8, Annexure A.
Page 8.
Yes.
Page 8.
My lord, it's an order dated 20th of February 2025.
Yes.
Passed in the present proceeding. Second paragraph I am reading. After hearing the parties and considering the materials on record, I find that the matter can be more effectively adjudicated after allowing the respondents to file a report in the form of an affidavit dealing with the principal grievances of the petitioners, stating relevant facts and disclosing necessary documents for adjudication of the issues raised. Below, the timeline is fixed. Please turn to the next page. 8th of May 2025, that timeline is extended. Now, Miller, kindly come to page 3 of this report. Paragraph 3. The present report in the form of an affidavit is prepared pursuant to the directions dated 20th February 2025 and 8th May 2025, passed by this Honorable Court. Then, my lord, paragraph 4. I have been advised, and to which advice I rely, to traverse and or to deal with only those allegations, contentions, pleadings, statements made in the said petition, which are pertinent and or material for the purpose of effective and appropriate adjudication of the issues involved in the said petition, and save what are specifically dealt with and or admitted herein below, the rest of the allegations, contentions, pleading statements made in the said petition shall be deemed to have been denied by this deponent. Thereafter, my lord, this is where I try to emphasize. Since the orders dated 20th February 2025 and 8th May 2025 only allows me to file a report in the form of an affidavit, thereby disclosing the stand of the High Court administration, the present report in the form of an affidavit is being affirmed and filed. By reason thereof, this deponent in this report in the form of an affidavit is not traversing and or dealing with each and every contention, pleading, statement, allegation made in the said petition. Such non-dealing and or non-traversing of each and every contention, pleading, statement, allegation made in the said petition is wholly without prejudice to the right of this deponent to affirm a regular affidavit in opposition if such situation arises. Then, my lord, paragraph 5. In the said petition, the petitioners inter alia pray for a direction for placing them as assistant registrars, court recording, in the vacancy of unreserved EC as notified in the notice dated 17/9/2021. Lord, kindly marks this date. The recruitment notice was dated 17/9/2021. On the date of the recruitment notice and the timeline fixed for applying, these petitioners did apply as unreserved candidate. They are not EC. The vacancies could not be filled up due to the non-availability of candidates of such category. What is such category? Unreserved EC category. The petitioners pray for a further direction to convert the vacancies from unreserved EC to unreserved in order to accommodate them. Paragraph 6 at page 5. Albeit the petitioners having prayed for the aforesaid reliefs, they have, however, consciously chose not to challenge the applicable rule in this regard. The petitioners applied for the post of Assistant Registrar Court Recording, High Court Original Side, as unreserved candidates in terms of the employment notice dated 17/9/2021. In the employment notice, the number of vacancy in unreserved category was 1. In the final merit list, the petitioners were placed at serial numbers 2 to 5 under the unreserved category. As such, they could not be offered appointment. Well, the first candidate who qualified as an unreserved, one post was there, he was accommodated. Paragraph 8. In terms of the recruitment notice dated 17/9/2021, there were 4 vacancies in the unreserved EC category. However, no suitable candidates were shortlisted for such category. The petitioners in the said petition pray that since the unreserved EC category seats are lying vacant, the petitioners may be accommodated in such post, being shortlisted candidates in the unreserved category, as done in other categories like scheduled caste and scheduled caste EC. However, such prayer of the petitioner cannot be acceded to, as the same is against the prevalent recruitment rule. Paragraph 10. The prevalent recruitment rule contained in notification number 50 EMP dated 1st March 2011 holds the field for the subject recruitment. Clause 8 of such notification specifically provide that as no curtailment of existing percentage of reservation for SC, ST and OBC category A and category B can be made. The reserved points for SC, EC, ST, EC, OBC category A, EC and OBC category B, EC. I pause here for a moment, Willard. Unreserved EC doesn't feature here. Shall be filled up by exempted category candidates belonging to SC, ST and OBC category A/category B only. The said clause further provide that in case of non-availability of a suitable exempted category candidate belonging to SC, ST or OBC category A and category B for any of such reserved point, the said vacancy shall be filled up by a non-exempted category candidate belonging to SC, ST or OBC category A and category B. Again, I pause. Unreserved EC is not here. A copy of such notification dated 1st of March 2011 is annexed here to and marked as with the letter C. The aforesaid notification specifically provides for accommodating SC, ST or OBC category A and category B non-exempted candidates in vacant seats of exempted candidates if no suitable candidate is available in exempted category only. The said notification does not place unreserved category at par with SC, ST or OBC and does not provide for such accommodation or conversion. Therefore, the prayer of the petitioners, besides being barred under clause 8 of the said notification, is misconceived. Willard, I rely on the exception, just one document from the exception filed on behalf of the petitioners. Please turn to page 10.
Page 10.
Page 10 of the exception.
Yes.
Kindly recalls, Millard, the recruitment notification is dated 17/9/2021. It is our contention, the High Court administration's contention, that this 17/9/2021 recruitment notification is governed by the 1st of March 2011 notification, which stipulates all this, what we have stated. Milord, the petitioners in their exception heavily rely upon page 10, which is dated 13 June 2025. It is my submission, Milord. This won't apply at all.
Because it's subsequent to the
Absolutely, absolutely. And secondly, I have demonstrated, Milord, from the annexure which I have appended in my report in the form of an affidavit, that this is a rule. This is a rule. Page 13, I have extracted and quoted it in my pleadings. Page 13 of my RIFA.
Yes.
It is my most humble submission, my lord. This is a rule. This is a result flowing from a statute. My lord, a result flowing from a statute can never be considered as an evil. My lord, it has to be acted upon. And a court, in exercise of its power of judicial review, cannot rewrite this.
And he was showing certain incidences where this has been followed by you in the
Milord, one instance is cited about a district judiciary, which is a separate recruitment process. I have no control. I'm the High Court administration. Even if, Milord, illegalities happen, can it be claimed, Milord? I ask myself, as a matter of right, as a matter of judicially enforceable legal right under Article 14. If something is wrong, it is wrong. I can't come before the court and say that extend the same benefit to me. And what is my initial application for? My initial application was for the post of assistant registrar, unreserved, not EC. I couldn't qualify in the one post. The topper qualified and he has been issued the appointment letter. Now I say that since these suitable candidates are not available, you convert it and accommodate me. This, in my most humble submission, Milord, can't be done. Those are my respectful submissions.
Mr. Mojumdar.
Lordship, my senior Mr. Mojumdar is not present.
Fix it on another day.
Another day, Lordship, kindly. Because, sir, computers are the next day they reply there.
Since there was a direction for a report, I have contended specifically, I have not dealt with the relevant paragraphs.
You want to file an opposition to it?
No, no, no. If it's not required, it's purely a question of law.
Heard Mr. Banerjee, learned senior advocate, appearing for the is not there.
My senior has arrived. Well, sir, last Gupta is on. But I'm for the petition, well. But there is an application for intervener. But it has been proposed by my senior in the matter, Mr. Ghosh, that this may be allowed, subject to the order passed by the appeal court, which said that there won't be any right in his favor if he joins the service, during the period when these proceedings are pending. Because
what order is by appeal court? Please place that. Because
I just upon your lordship what has actually happened. This is the writ petition which has been filed by the petitioner regarding a recruitment process of 2017. It has alleged that 2017 ought to have been favored with the chance to get an appointment. That has not been given. And what has happened subsequent there to 2017, since the vacancy remained unfilled, that vacancy was carried for the year 2021, to which the present applicant seeking impeachment has already been given appointment. That appointment was challenged for the learned single judge. Two separate appeals were carried forward from that petition, one by the High Court administration, the other by the petition applicant itself. In connection with those two appeals, the petition was allowed to join, and there's a with a rider that until this.
Who is appearing for the High Court here?
Your Lordship, I'm led by Mr. Siddhartha Banerjee. He has not come to court today. Your Lordship, his father is undergoing a surgery. He's appearing for the High Court.
No, I should hear them also, because.
But so far as the application is concerned,
you may not oppose. Somebody else might oppose if it is favoring you. I don't know. Let the other side also come.
Well, I may indicate one thing, sir. If this application been taken out GA number 1 of 2025, that's at the behest of the intervener. If Lordship kindly takes that my affidavit in opposition to that application. I have filed an affidavit in opposition, and they have filed their reply to that. Kindly take my affidavit in opposition to that application at page that just has one annexure, my lord. That affidavit in opposition has one annexure. In that, but may it be taken on record. I served upon them, that may be taken on record, my lord. I have disclosed. Yeah, will be to file on. I don't put a recording. In the opposition, that I have disclosed the order. That this has arisen from the earlier round of writ petition that I had filed. That in that writ petition, there was an interim order by the Honorable Single Judge in my favor, staying the recruitment process. Now, my lord, from that, this appeal was preferred. Now, in the appeal, my lord, if Lordship kindly comes to page number 3, internal page 3 of the appeal, my lord, of the order, my lord, the last paragraph. In view of the nature of the controversy pending adjudication before the writ court, and since the respondent number 4 has emerged successful in the recruitment process, this respondent number 4 there is the intervener here. Such modification, in our opinion, would not in any manner prejudice the case of the writ petitioner or affect the merits of the matter pending before the writ court. We therefore modify the order passed by the Honorable Single Judge so as to allow the appellants to process the appointment of respondent number 4 with the view to utilization of his services, but with clear indication that the appointment will be subject to the result of the writ petition. The respondent number 4, who is also a party to the present proceedings and represented through an advocate, shall not claim any accrual of any right whatsoever by virtue of interim order as modified by this court today. Appointment of respondent number 4 would be subject to the result of the writ petition. We make it clear.
So in
all
any case, even if you are not added, you are bound by the result of the writ
Yes,
petition.
please.
What will you do by getting added here?
That is the point, my lord.
Whatever it is now, the division bench has said that your appointment would be
I'm
subject to the result of the writ petition. So what will you do by getting added?
That is subject to WPO 919, my lord. Now 919, my lord, though there is a rider to at the time of appointment which is given in my favor, that my appointment shall not be, but my lord, leaving behind 919, what the present petition is trying
919.
919 in connection with which this appeal was taken out, my lord. The appeal.
So that's a different writ petition, not
That's a
before.
different writ petition, my lord.
He can be added subject to whatever rights he has as per
My
the
lord, I am not-
order.
not-
That order, he cannot get any equity.
No,
He
no,
has
I'm
no
not
right.
asking for equity.
It's already bound.
Because
Yes,
my lord,
already covered by this order. Lordship will dispose of it, keep it for hearing, my lord. I come and argue.
And my
this
lord,
matter.
subject to liberty be granted to me to file an opposition in the writ petition.
In
What
the
writ petition?
petition,
Please wait. What
My lord,
opposition
the
will you file to
vacancy,
this
my
writ
lord,
petition?
kindly appreciate the vacancy against which this matter was filed, my lord. That vacancy.
What is 919? What is
My
the
lord,
subject matter of
919 is the
919?
recruitment process of 2021. There's a post indicated for OBC BEC exempted category. Now, this particular post in 2021 recruitment is a carried forward post from the year 2017.
And what is your right to get added in this writ
My lord,
petition?
because the same vacancy which my learned petitioner, the petitioner was harping on, seeking appointment, that has already been filled up by a subsequent recruitment process of the year 2021.
Within this order, my lord, he will have no right in the post. My right to challenge remains. That's the division
My
bench
lord,
order.
that's the independent right of what.
No, you don't have any independent right. The order is subject to this order.
My lord,
The one has preferred
my
an
lord,
appeal
kindly
with this.
appreciate, my
My
lord.
lord, he went to division bench with deepest
No,
of
he did not.
respect.
He did not. He did
My
not.
lord,
Authority went.
authority went
What
to
is
division
the subject matter of challenge in your writ petition, Mr.
Will
Ghosh?
kindly look at my writ petition. What is the challenge, Miller, in my writ petition? Could kindly look at the prayers what I have claimed. Kindly look at Miller, page 20, Miller, of the prayers in question. For appointment by directing the High Court administrator to appoint the petitioner as the post of the Assistant Register Court Recording High Court to take recourse. These service rules, Miller, were withheld. Miller, in his time, Miller, the rules were applied. But
And how are you affected by any order being passed in this petition?
Because, my lord, I do not know, first of all, what prayers has been made in the writ petition. I'm not a party to the proceeding. Secondly, my
Then
lord,
how are you
my lord,
suddenly claiming to be affected
my
by
lord,
a
why I'm saying so? Because
petition of which?
919, the earlier round of writ petition, was assailed on the ground that this person who has been favored with a applied under category of OBC, he has been given appointment under OBC BEC. Now that particular vacancy was lying vacant since 2017, the recruitment process which is challenged before your lordship. Now that was carried in the year 2021. That vacancy got filled up. Now, my lord, at the same point in time, what the petition is trying to do in the other writ petition, being WP 59, he is saying that the benefit which has been given to me from OBCB to OBCEC, that should not have been given.
That is not the prayer. It is you are not a party here.
My lord, the rule says so. My lord, the rule says so. My lord,
So if the rule says so, then even if he doesn't pray for it, if the rules say the rules will
my lord,
have
that's
their
what I'm saying. That's an independent right of the petitioner. However, my lord, he cannot have both the legs on two different boats at the same point in time, because on the one hand, he's saying that I should not be favored with a benefit, whereas on the contrary,
that is not before me. That is not the
my lord,
prayer in this
my lord,
petition.
that is the exact point, my lord, for which I am saying, my lord, at least let me be implicated as a
That
party.
everybody can come and say for the sake of apprehension that I have an apprehension that this maybe the prayer. You first get yourself ready with the prayers. If the prayers don't affect you,
My
why
lord, at
unnecessarily will you get
My
added
lord,
in
at least, my
enlarge
lord,
the
I
scope
may
of
be,
this proceeding?
my lord, what I am humbly beseeching before your lordship, my lord, if I be added as a party and a copy of the writ
Sir, to
petition,
be added as a party, you have to show that you have a right to be added. Your presence is
my lord,
necessary.
my
Why
lord,
are you
kindly come to
necessary
their
for the
opposition, my lord.
adjudication of this writ
My
petition?
lord,
You cannot just
I'll
bargain
go
as
from
a
their
party.
opposition where my rights are getting affected, my lord. Their opposition to the GM.
How are you important and how is your presence going to affect the adjudication of the proceedings, sir? That is the test.
My lord, there is only one vacancy which has been carried forward and being filled up by me. That is a subject matter of challenge before the other writ petition. Now he's arguing on the same thing which has been carried forward by going back 5 years back, my lord, in the year 2017. Now, my lord, vacancy, if the High Court administration wants to create a separate vacancy, I am no one to stand, my lord, in the way. But if it says that no, that should have been given over there, correct, at that point in time, then my vacancy and my rights is getting
His
affected.
appointment will get you out of the appointment.
Because, my lord, my appointment is
My lord,
subject
kindly
to
have a
the
look at his
observation
perhaps, my lord, not correct. My lord, if there was a post, my lord, authority preferred an appeal. It was the authority's prayer, my lord. My lord, kindly have a look at, my lord, no one has challenged the order. My lord, kindly have a look at, my lord, last paragraph. Internal page 3. Now, 4টা দেখালেই হতো। My lord, kindly have a look at internal page 3 of, my lord, the order passed by Honorable Justice Madhuresh Prasad, my lord, bench and my lord, Supratim Bhattacharya. Kindly have a look at it, my lord. In view of the controversies, in view of the nature of controversy pending adjudication before the writ court, since the respondent number 4 has emerged as the successful bidder, so he was a part.
Respondent number 4 is the intervener.
Me. As a successful bidder in the recruitment process, such modification, in our opinion, would not in any way prejudice the writ petitioner, which is me. 4 is him, or affect the merits of the matter pending before the writ court. Therefore, we modify the order passed by the Honorable Single Judge as to allow the appellant to process the appointment of the respondent number 4 with a view of utilization of his service, but with a clear indication that the appointment will be subject to the result of the writ petition. The respondent number 4, who is also a party to the present proceedings and presented to the learned advocate, shall not claim accrual of any right whatsoever by virtue of the interim order as modified by this court today. Appointment of the would be subject to the result of the writ petition. All good. So, my lord, he cannot claim any right. My lord, he is only temporarily functioning in that post with subject to the result of the writ petition. So, he has no right. No one challenged this order. With deepest of respect, my lord, we cannot, my lord, sit in over this, my lord, order of the division bench. You invited the court to pass an order, and now you are trying the court to breach the order.
My lord, if I may say so, my lord. My lord, 59, the other writ petition was filed by the same petitioner challenging that I have been favored with a benefit. What was the benefit? That the rules does not contemplate that a vacancy of OBC was there. First of all, so I should not have applied under the category of OBC. Secondly, though I have applied under the category of OBC, I have been given appointment under the category of OBC EC. When the High Court administration came up and said, see, there is a rule. The rule which my learned senior is relying upon. The rule permits the High Court that in an event an appropriate vacancy under exempted category is not being allowed, then the vertical vacancy which is lying over there will move horizontally. through means of which I have been appointed. Now, in the other writ petition, in the 2021 recruitment process, the same writ petitioner has not applied under the post of OBC. He has applied in the general category. Now, that went up before the appeal court. High Court says we are in dearth of some staffs. We need a staff, and for this limited purpose, we are saying that an appointment subject to outcome of the writ petition may be given. Now, my lord, at the same point in time, when this when the other writ petition was pending, at the same point in time, this writ petition was preferred. Now, kindly appreciate what has fallen from Mr. Ghosh's submission, my lord. He has preferred the writ petition on the count that the benefit under the High Court rules, which ought to have been given in the year 2017, that was not forwarded to the petitioner. That I do not have a stand, my lord. I do not have a stand in there. Now, my lord, my only contention is a vacancy 2017 was lying. There's only one vacancy. That was carried forward in the year 2021. Now, 2021, I came out as a candidate, successful candidate. I have been given appointment. Now, my lord, there are two things at the same point in time which is hovering around. One is whether any vacancy can be created by the High Court administration, that is completely on the domain of the High Court administration. But if it is affect my right, because if it says that your lordship's order today says that rule should have been forwarded to him, that benefit should have been given under that rule, then it is indirectly inflicting upon my rights. Though my right is subject to a rider that subject to the outcome of 919. Now, 919 need not be prosecuted at that point in time when there will be a culmination of a finality of this order passed in regard to this proceeding.
What is 919 is your petition.
919 is my writ petition. In that, my lord, an order has been passed. My lord, both my lord, High Court administration and he invited an order that please let me work, because High Court administration felt my lordship has to discharge functions. So, my lord, as a my lord, without giving any right, my lord, let him my lord function. I said, my lord, what benefit? Now, my lord, they were
The
given that
subject matter of 919 and this writ petition are different.
Of course, in respect of two different my lord posts, two different selection process.
Two different selection process.
Correct.
The post is same, which has been carried forward.
Mr. Mukherjee, can't be the same. My lord, now, my lord, what I say, that when I apply, you say that this
If
rules,
it is only one post, Mr. Ghosh, which is being carried
Yes,
forward,
correct.
then it has to be the same.
Millard, yes, Millard, that's the reason I said, Millard, he cannot get Millard better right than what he has in the writ petition in the order of the division bench. Millard, let us Millard take Millard. Now Millard is lost. We Millard, no Millard. Now Millard, he has no right. So this will be the purport of the order which will go in. I said Millard immediately, Millard. This is the purport. He cannot get more than anything what is in page number 4. Then Lordship has to clarify without prejudice Millard to his rights and contention or not create inequity. Lordship has to put that in. Because both three parties have accepted the order.
My lord, the difficulty which you are facing, my lord, is not the
Millard, what is my case here? My case is that for him, Millard, you will apply a set of rules and regulation which will permit him to take that vertical Millard advantage and get into the post. But when I am eligible, you will not give me, but you will go with some other process, Millard. This is Millard the short stand. So it's an Article 14 breach.
Millard, since my right,
and I showed your lordship, and I show he has no right, Millard. And what is that's as per the petition. And Millard, so far as Millard, I had showed on last occasion, 4 posts have been created, Millard. Why he is aggrieved? One of us has to go to that post.
My lord, kindly assume a situation, my lord. There will be outcome of this proceeding, WPO 13 of 2024. Separately, there will be WPO 919 of 2024, which has also been filed by the same writ petition. My lord, there will be a conflict of interest in both the proceeding. My lord, either both the writ petition can be tagged along and moved.
That I cannot.
My lord, if that is not possible, what I am humbly beseeching, my lord, let me add it as a party, because
you are a party there.
I am a party there because
he's a party there. Respond number 4.
My appointment was challenged, my lord, in that.
Yes, naturally, and it was fully stayed on the High Court, saying, my lord, that I am entitled, my lord, to the post. There's a single bench order. Now, my lord, since my lord, this cannot continue. Lordship has to discharge my lord function. So he is functioning as a temporary basis in that post. And now there are 20
added as a party to this,
subject to in terms of the order of the division.
Yes, of course.
I cannot stand
in. May be granted to at least file the opposition so that I can bring down the records of 919, because that will be my limited scope. My lord, by worst case, my lord, I am not even a.
His post, my lord. It's only a temporary post, and today, my lord, kindly have the notification of 12th of August 2025.
Temporary post, but I have been forwarded with all the benefits.
No, absolutely.
My lord, the court does not talk about temporary post.
Yes, it's absolutely
GA1.
You have no right.
GA1 of 2025.
That's a court matter.
In my application for relief against conviction under section 463 of the Companies Act. So, my affidavit in reply, I am told this hardly any justification, but this is whole matter. But I can start today.
Well, can start, but I will only seek leave to produce a report, my lord, because this case is not maintainable 463(2). Because prosecution has already started before filing the case.
You have not said this in the opposition.
No, I
that
have
is
not.
here.
It was unfortunately not stated in the opposition, but this remains a fact, my lord.
Then let them give that.
Yes, that I will file a
I can
report on
also-
affidavit.
goes if
Yes,
in any case.
If there is, then I'll deal with it in my affidavit in reply. Let them give the records.
So,
one small report, my lord. I will produce the lower court petition and the order.
That should have been.
I'll give him an opportunity to
Yes.
file a report.
And then I shall give my reply.
Yes, yes, yes.
You are appearing for Mr. Dasgupta?
For the deputy registrar of companies, my lord.
Deputy registrar.
My lord.
There is a registrar.
On behalf of the
his phone number 1 and 2.
One both, my lord, both.
Both. लिखे नहीं दीदी लिखे नहीं Mr. Dasgupta, learned advocate. A minute.
Item number 5 and 6, my lord, together your lordship are hearing the matter, my lord. Mr. Chakraborty was arguing in the first matter, and Mr. Vipul Kundolia was senior advocate was appearing, my lord. He requested that the matter can be, if the matter can be taken up on 26th, my lord, because next week, my lord, there are some difficulties.
26th, it won't be possible. 27th.
Both matters.
Oh, no, this is not assigned. Okay. 26th you want, yes. लिखे नहीं रखता order. 5 and 6.
5 and 6.
The two things, same orders. No, there is a division bench.
Yes.
Item 7.